Welcome, everyone, to the January 13, 2023 California Board Behavioral Sciences Policy and Advocacy Committee meeting. My name is Max Disposti, pronouns him as. I'm the chairperson of this committee and also the chairperson for the Board of Behavioral Sciences. Before we convene, I would like to remind everyone that is present that the board is a consumer protection agency that is charged with administering and enforcing the board laws. Where protections of the public is inconsistent with other interests sought to be promoted, the protections of the public shall be paramount. The Board of Behavioral Sciences will be holding this public meeting in person and via WebEx platform. Board members will be participating in person and remotely today. I will announce when we are accepting public comments on the various issues on the agenda today. And for each public comments period, we will first be accepting comments from the participant in the audience. But in this case, this is, as you can tell, a script that we adopt for the board meetings in person in Sacramento. But for today, the order is as it comes for the questions from the public. The moderator, though, will open the lines as appropriate so that the remote audience members can comment, and each commentator will have 2 minutes to comment. Moderator, good afternoon again, and thank you for helping us today. Would you please provide the audience instruction how they might participate during the meeting and at the appropriate times? Thank you again.
Certainly. So we'll be using the WebEx Q&A feature to facilitate public comment. If you have something to comment about during a given agenda item, you can look, we will open up a Q&A feature and you'll see a question mark typically in the lower right of your WebEx screen, or if you're on a mobile device, it will be behind the 3-dot other options. You can type the word comment and click send, and that will let us know that you'd like to make a comment, or you may raise your hand by clicking on the hand icon, either next to your name at the bottom of the screen or on a WebEx, on a mobile device behind the 3-dot other options. Each speaker will have 2 minutes to speak with a 15-second warning, and we will then mute the first person and go on to the next.
Wonderful, moderator. Thank you so much.
You're welcome.
Now we're moving to the agenda items, which is called to order. And just to establish a quorum for this policy advocacy meeting, for my fellow board members, when during the roll call, please introduce yourself and let the public know whether you're a public or licensed member. And I believe today, I don't know if it's Christina or Steve helping us with the roll call.
Christina is here.
Hi, Christina. Thank you so much.
Hi. Good afternoon, members.
Good afternoon.
Max Disposti.
I'm here. I'm public member and board chair.
Abigail Ortega.
LCSW member.
John Sovet.
Present, LMFT member, and my pronouns are he, him.
Wendy Strack.
Present, public member.
We have a quorum.
Wonderful. Thank you so much. And this is item 2 of the agenda. This is usually the time where we do some introductions for the people that are mostly for agency and associations that are here on the web connected to us. Moderator, if you don't mind to open to the public. So if there are any of the agency representations that would like to introduce themselves, we can do so now. And thank you.
Certainly. And if anyone would like to introduce themselves, you may look for the hand icon, which might be behind the 3-dot other options if you're on a mobile device, or our call-in users can use *3 to raise their hand if they would like to introduce themselves. And I see no requests at this time.
Thank you. No request?
No?
Okay. Thank you. Then we can move back to our agenda item, and thank you so much. At this time, we're going to skip the item 3 of our agenda, which is the consent calendar. We actually don't have the minutes ready from the previous meeting, so we are not ready to vote. I think now we can move to item number 4. Just give me a second. Just a second. Number 4, our consent calendar. And this is moving directly to discussion and possible recommendation regarding amendments to the board's temporary practice allowance from bill proposal. And I believe this is Roseanne introducing, right,
Yes,
Roseanne?
that's
Thank
correct.
you so much.
Thanks, Max.
Mhm.
So the board has a bill proposal this year that it approved language at its November 4th, 2022 meeting. And what the bill proposal would do is it would allow a 30-day temporary practice allowance to qualifying therapists who are licensed in another state and whose client is visiting California or is in the process of moving here. I'm actually happy to announce that just this morning that bill showed up as introduced in the legislature system, introduced last night as AB 232, and the author is Assemblymember Aguiar Curry. So the language that was approved by the board, I've shown in attachment A of your materials here. And so it allows the licensee in another state, if they're current, active, and unrestricted in an equivalent profession, to have a temporary practice allowance to see a client traveling or relocating here for a period of 30 consecutive days in any calendar year. The client must be located in California, and the client must have been the licensee's client immediately before the client traveled to California. The therapist needs to inform the client of the limited time frame of the services, provide their license information, and provide the client with the board's internet address. And then prior to providing services, the therapist must provide the board with specified information about their license, identity, and contact information. And we included a sunset date in the proposal to align with the board's 2026 sunset date in case any adjustments to the law need to be made after implementation. So what happens after the board approves a legislative proposal is it goes to legislative council for drafting. And what legislative council is, it's the legislature's legal counsel. So they will look at a language in the bill and kind of make sure that all of the legal use is correct, to put it simply. And so sometimes they will make some fairly minor changes or technical changes that may be of some minor substance. And so that's what happened in this case. Our leg counsel, they made a few legal changes to the wording. A couple of things that they did, everything that they did, the language that legislative counsel drafted is what was introduced today. And that's shown in attachment B. And so a couple of things that they did, they instead of referencing in the bills sections saying nothing in this chapter should restrict a person from practicing, they wanted to reference a particular code section. They wanted to talk about a marriage and family therapists being permitted to provide services versus offering services. And in certain instances, when we referred to the licensee as the licensee, they wanted to refer to them as the person instead. So just some minor things like that, but I did tell them that I wanted to have the board take a look and approve that language just because it was some technical changes that it kind of borderlined on whether or not they're substantive or not. So what those changes are shown in attachment B. Another thing, we got a ledge counsel that I think was really thorough and did a really great job at sort of looking at some of our practice acts and some of the other related sections when they were drafting this bill. And so the legislative council that reviewed it recommended a few other minor but definitely technical and substantive changes to a few other code sections in our practice acts that are related to what this bill is doing. And so the first one was Business and Professions Code section 4980. And that is LMFT law, and that section talks about requiring a license to engage in the practice of marriage and family therapy. And so that's why it's related to the sections being proposed. And they wanted to make some cleanup changes. They noticed that section 4980 states that no person may engage in the practice of marriage and family therapy as defined by section 4980.02 unless they hold a valid license as a marriage and family therapist. And Ledge Council notes that technically the language should state that the license must be a valid license to practice marriage and family therapy pursuant to this chapter, meaning pursuant to the chapter that establishes MFT licensure. So that's a very old section, 4980, that was written a very long time ago. And so I agree that that is a technical change that is wise to make. And I appreciate that person's thoroughness in taking a look at that. So that's one change. Another change was in a related section in LMFT law 4980.30. That section also specifies the licenses required in order to practice. It talks about needing a license from the board to be able to practice and to advertise. So the Ledge Council stated that saying practice and advertising, it technically legally implies that both actions need to be taken place together to be prohibited. So if you're practicing and advertising, you need to have a license. But if you're only practicing or only advertising, it implies that it's allowed. So very technical, we're getting very technical, but I think it is definitely important to make that legal change. And they're recommending using the term practice or advertising instead. So that's another change that they suggested. And then the last recommendation they had to do with LCSW law. There is a section 4991.2 at the beginning of the LCSW Practice Act. And they noted that unlike the LMFT or LPCC Practice Acts, the LCSW law does not specifically define the word board anywhere as meaning Board of Behavioral Sciences. Our other practice acts do. And so, and our bill refers to the term board. So they feel that that's why it's related. So they also noted that LCSW law does not have a definition section at the beginning of the practice acts to commonly define terms like the LMFT and LPCC practice acts do. And that's likely because the LCSW Practice Act is our oldest practice act. It was written a very long time ago. It's structured very differently than others. So staff and legislative council kind of talked about that. And what we ended up deciding is that it might be a good idea to recommend that 4991.2, which is near the beginning of the LCSW Practice Act and currently defines one term, that we amend that section to also have a subsection B that includes a definition of the term board, meaning the Board of Behavioral Sciences. And then in the future, then we would have that sort of definition section already being built. And if through omnibus bill or future registration, we wanted to add additional definitions to the LCSW Practice Act, that we could do it there. So that was the recommendation. They also made a technical recommendation that the beginning of the LCSW Practice Act, which is 4991 through 4991.2, it doesn't have an article number, which is really technical way that the practice acts are organized. So they suggested at the top of 4991 that be titled Article 1 General Provisions. So all of those brand new changes to the new sections are shown in attachment C. And so what I'm looking at today is, after discussion, possibly direct staff to make any discussed changes and any non-substantive changes to the language in attachments B and C, and then approve the language in attachments B and C, as well as the use of the insertion of the term Article 1 as noted above. That's not included in the language because Ledge Council didn't really know how to do that yet, without how to portray that. And then ask that that be amended into the legislative proposal that the board is currently pursuing, which is AB 232 now. So hopefully that's clear. I know it's really technical. I'm open to any questions you might have.
Thank you, Roseanne. And not that I'm even trying to attempt to summarize what you said, but it was very clear to me. I think the substantially really all the amendments are quite technical. And I don't see any major, but I definitely want to open the discussion, and also thank you for the follow up. This bill has been moving actually quite fast in comparison to other, this just started during the COVID emergency, and loops that we have seen and challenges that we have experienced with licensee and having clients outside the state and so forth. So this is really actually very useful. But would like to open to the board if there are any other questions, concerns, or sharing. And please help you just jump in the conversation because I see some of you and but not all of you all the time.
So Roseanne, everything looks really clear, and I appreciate whoever the person was who dug through and found all those like minor things. My brain does not work that way, but I definitely appreciate it. The one thing that I want to make sure we always keep track of is that it is, and it's in the language, and make sure we keep track of that it's an immediate continuum of care. Once again, worked with them immediately before, because I think I want to be really careful that we don't leave any loopholes in here for some of these major corporate app-based and online systems to find a way, oh, they had one session, so this is a continuum of care. Because I just want to make sure we're really paying attention to how we can manage that.
Right.
No, just for the record, that was John Sobek. I just need to, because we're recording two audios. So John, and go ahead, Roseanne.
Yeah, so I think that the language still covers, the language hasn't changed in that respect in attachment B. If you look at section 4980.11, which is the MFT version, the other ones are all modeled to be very similar, the same. It says for a period not to exceed 30 consecutive days in any calendar year. And so that language is still in there. And I think that eliminates the loophole. And also the requirement that the person was the person's client immediately before the client became located in California. That should solve that issue. But if anybody disagrees, definitely.
This is John Sobek again. The question is, does having one session with someone and then doing 30 with them in California fall under that immediate client language? So if I'm in New Mexico and I'm a person working for one of these large companies and I do one session with you and then I can promise you 30 sessions in California, is that actually covered under the way the language is currently written?
So they would get 30 consecutive calendar days.
Right.
So
I guess what I'm talking about is the potential of I've seen you once in another state. That makes you a client. And now we're saying, and I can see you for 30 sessions in I can see you for 30 days in California. I'm really trying to be hyper aware of this because as a clinician, we're watching all of these encroachments into, our practices. And once again, is one client session previous to them setting this up continued an immediate before? And do we need to think about that in this languaging?
That's an interesting question. Yeah, as long as they were the client before the person became located in California, then yes, but they would have needed to have been in New Mexico to see them. So, and they would only get 30 consecutive days. So it's not like they could say, okay, over 30 weeks, they would have to basically, could they see them every day for 30 days? Yes, in theory. I guess the board needs to weigh whether or not, how concerned they are with that.
I just from the public standpoint of view, I understand the concerns. So John, I do agree with that risk, especially because there is a lot of exploitations around, the big online company. At the same time, I can see for everyone else, if you do have a client and then there is a transfer, you want to give enough time to that person, to that clinician, obviously to connect the person to the right provider and, maybe give them another chance for another couple of sessions if it's a weekly session. So the month, as you all know, goes quite fast, right? I would like to lead that. I don't know how you feel about this, John, but that short period of time just to be able to even connect the person to the right resources so it doesn't become automatically, boom, I'll drop you. And so there is also that, right?
Right. And my concern is not with a 30-day period. I actually, in our last discussion, really encouraged that to place limits on it and make them consecutive days, not just 30 days in a calendar year. It's about this definition of who isn't a client in care. It's about this idea. I have seen a client once in a different state under one of these auspices. can I then see them for 30 days here because they were immediately under my care? And that's just the loophole I'm kind of like sussing through. It may be over worrying about something, but I just wanted to see if we need to be considered that in our languaging.
And if we do, how would we even apply something like that? If you have any, I don't know if you want to brainstorm a little bit that, John. And then maybe we can hear from others in case this is.
And I would actually defer to Roseanne because I don't write legislative language, but is that something that's almost impossible to put into a bill? Is it not enforceable? I mean, I'm putting it out there, but I don't know if it actually makes any sense to do.
Well, it's manageable. I think is the legislatively we could do that. I think, well, maybe, but managing it that we wouldn't be able to really. I don't know how we would actually enforce that. It would be pretty difficult.
It would be basic. Yeah, we wouldn't be able to prove that. I think it's getting a little bit beyond. It's not an exception I saw anywhere else. I don't think we would be able to actually be sure other than having them say, yes, they were my client for X number of sessions. But even if it was like 2 sessions, I mean, they could have met with them for 2 days ahead of time. If they're going to meet with them for every day for 30 consecutive days, they could meet with them beforehand for 30 consecutive days too. So I don't know how we would manage that. I think that we do have a sunset date built into the bill if we encounter an unintended consequence, that we see that this starts happening, that we could figure out what to do from there to address it. But I don't know. It'd be interesting to hear other feedback from stakeholders.
In fact, we have Abigail now that she has raised her hands. Abigail.
I would say there are many cases where that is a possibility. Sometimes you have students, right? Because the consumers don't necessarily know the law that a therapist in one state can't practice in another state, so they may seek support. And so, yeah, maybe it's just 1 or 2 sessions, and then you inform them, oh, when you go back to college, or when you start college, or if you move to another state, that I can no longer see you. I mean, that's happened quite a few times in my experience, and so it is possible. And I don't see like it being so much a harm to the consumer. If anything, it gives them the opportunity to get support when they do switch over. And I think that by the sunset day, if we see abuse of that privilege, then we can talk about it again. But in the meantime, that will happen, and I think that's fine.
Thank you, Abigail.
Mm-hmm.
I always remind people, please introduce yourself, because for people that don't see videos, they are listening to us, we want to make sure they know who is speaking. And in this case, I introduce you, so it's good. Thank you, Abigail. Anyone else from the board? I mean, from our board, but then otherwise we can also open. I would like to open to the public if there are any comments, or there are even possible suggestions of a motion. Anyone else from the board first? Okay, we're good. Moderator, if you can please open to the public and see if there are any comments in there. Thank you.
Certainly, and we're opening up the WebEx Q&A feature to facilitate public comment. If you've got a comment on this topic, you can look for the question mark icon, typically in the lower right of your computer screen. Type comment into that text box and click send, or you can raise your hand by clicking on the hand icon. And if you are a call-in user, you can use *3 to raise your hand. Each person will have 2 minutes to speak. And I do not see any requests for comment. Shall I close that feature?
Yes, thank you.
You're welcome.
At this point, in coming back, I would like to make a motion to approve, what am I? I'm trying to find my documents when I was leading the motion. Maybe Rosanna, you can help me, but definitely I would like to make a motion approval, obviously, in consideration all the technical, not substantial changes that might occur that need to be brought. And go ahead, Rosanna.
Yeah, okay, so the motion would be to direct staff to make any non-substantive changes to language in attachment B and C, and recommend that the board approve the language in attachment B and C for use in AB 232, which the board is currently pursuing, and also to add Article 1 titled Article 1 General Provisions in front of BPC 4991.
Yes, thank you, Roseanne. I'm always afraid to switch videos when I go to my documents because then I don't want to lose you all. That will be the motion, and I would like to add the reason why I'm moving also is because I know that we had an urgency with this bill to really close an existing dynamics where we have seen and witnessed a lot of unclarity by a lot of our licensee on performing, for a long period of time therapy with individuals that were out of state and vice versa. So I think this will help us at least to close the loop and move forward. And then I agree with what Abigail was saying about the sunset review. If we have more data by then to readjust and readdress some of these potential issues, that will be also the right time to do so. So my motion is on the floor. If we have a second.
I'll second.
Who was that? I'm sorry.
Oh, sorry, it's Wendy.
Thank you, Wendy. So we have a motion on the floor moved by me and second by Wendy Strack. Any other comments on the motion? No, at this point, I know if Sabina was here, will tell me to go back to the public because now we have a motion on the floor. So moderator, if you can please open and see if there are any comments on the motion.
Certainly.
Thank you.
You're welcome. So we've opened up the WebEx Q&A feature to facilitate public comment. If anyone would like to make a comment on the motion, you can look for the question mark icon, type the word comment in that text box and click send, or anyone may raise their hand by clicking on the hand icon. And if you're a call-in user, you can press *3 to raise your hand. We do have a request to comment from attendee named Kathy Atkins. And Kathy, as a reminder, you will have 2 minutes to speak. And I'll send you a request to unmute your microphone. You're unmuted.
Hi, Kathy Atkins from CAMT. I just wanted to thank the BBS for pursuing this kind of issue and subject. There's a lot of confusion out there, and while no law is perfect in its language, especially something that's newer to our practice field, I think it's great that we're trying to clarify it as well as be a leader, one of the leaders nationally on how to provide direction on this issue. So I just wanted to say thank you.
Thank you. Anyone else?
No, there are no other requests for comment at this time. Shall I close the public comment feature?
Thank you. Yes. Thank you.
You're welcome.
Okay, so we have a motion on the floor. If there are not any other comments from my fellow board members, I'm running around here. Looks like we are good. Then we can call a vote. Christine, if you can help us, please.
Max Disposti,
Yes.
Abigail Ortega,
Yes.
Wendy Strack,
Yes.
John Sovek.
Yes.
Motion carries.
Thank you, and thank you all. We're now moving on item number 5 in our agenda, discussion and possible recommendation regarding the definition of a supervisee. And Roseanne, again, thank you so much.
Yeah, so this conversation came up in a response to a few questions that both the board and CAMT have received. and our realization that we had slightly different answers, not slightly, we had different answers to the question. So there's a need for clarification that was discovered. Currently, the board's practice acts use the term supervisee, but we don't define specifically what a supervisee is. In most instances, a definition is likely not needed because in the context where it's used in the board's practice acts, it can be reasonably inferred to mean any individual required by the board to be under supervision. An individual might be required to be under supervision for numerous reasons. And so, for example, they're an associate and they're gaining hours toward licensure. They're working in a non-exempt setting and therefore maybe they're done with their hours, but they are required to maintain a registration and supervision in order to keep providing clinical services before they become fully licensed. They might be working under the 90-day rule. They might be an MFT trainee who is counting hours toward licensure. So all of those situations, it's implied that a supervisee, it's a simple word rather than listing all of those different scenarios out each time we use the word supervisee. That's what a supervisee is generally in the context of the board's practice act means. But there are two particular instances where that above might not apply. And so there may be a need for some clarification in those particular instances. So the first one is where there is a definition in law of direct supervisor contact, and that can be found in identical language can be found in LMFT, LCSW, and LPCC code. And so these subsections define individual supervision, triadic supervision, and group supervision for purposes of direct supervisor contact. And that's required when somebody's gaining supervised hours toward licensure. They need to meet with their supervisor a certain number of hours per week. And that can either be as an individual, in a triad, 2 people, or in a group. The term supervisees in the contact again refers to individuals required to be under supervision by the board. But the law talks about, and specifically with group and triadic supervision, for group supervision, it's defined as consisting of 1 supervisor and no more than 8 supervisees. So the question that was posed to the board was, I have a group of 8 supervisees. One of the persons happens to have a license, but we have them in the group because we feel that they need some extra supervision and they would benefit from this. So does that count as one of the 8 people that is allowed? And so for the way we typically answer that question, yes, that is one of the 8 supervisees because, we think that the purpose kind of limiting it to 8 is to ensure that everybody gets adequate supervision, that the group supervisor has enough time to pay attention to each supervisee in the group, and so that they are getting a quality supervision. But if you apply the typical somebody required to be on supervision by the board, that could be a board licensee or a trainee or somebody under the 90-day rule. In this particular instance, that definition wouldn't account for somebody who might be, just a licensee who needs some extra supervision, or maybe a psychologist trainee who's in the supervisor group too. And so there might be some additional clarification that is needed there. So some possible solutions would be to add a paragraph to first there should be a discussion of whether the term supervisee should only include board registrants and associate or 90-day rule people or trainees, or we go with what we think was the intended definition is it's limited to 8 individuals. And if that's the case, a couple of suggestions would be to add a paragraph to the subdivision of law that states, for purposes of the subdivision, supervisee really refers to any participant in supervision as defined in where we list what supervision is defined as with a supervisor. Or we can, instead of defining individual and triadic and group supervision as consisting of 1 supervisor and a specified number of supervisees, we can define them as one supervisor and a specified number of either individuals or participants or something like that. So that's the first part of this memo. Max, you want me to stop there so we can discuss this and then we can go on to the second piece? I think that might be the least confusing way to do it.
Yeah, thank you for offering that, Roseanne. Yes. I was thinking about, yes, thank you. Maybe we can start here. I was thinking about, in my understanding, obviously, not being a clinical person myself, but in running though, being a service provider, provide clinical services, I noticed different instances where obviously in a clinical supervision space, maybe there is another licensee that is there that maybe it's a newly supervisor. It wants to get a little bit that, which happened in my space, is, hey, I would like to see there because this other supervisor has 20 years of experience that really can gain some perspective. But that's the only exception. But then, but obviously this supervisor is not bringing their own cases to the other supervisor. I mean, this individual is not bringing their own cases to the other supervisor. They are not so adding to the workload of how many people need to be supervised. So in that case, only in that exception, it makes sense that that person, because it's not even required to be there, shouldn't be part of the 8. In any other, I can see, and I might be wrong again, just based on my own experience here, I can see how this could be the only exception, but at that point, then it's not even a requirement. Again, this person is not bringing more work into the team, but actually just a different perspective. But in any other circumstances, when a supervisee is obligated to be there because of regulations of the BBS, or because they're acquiring hours, or, you know, in any stage of their licensure, that person counts as an individual because they bring their own cases to the supervisor. So at that point, you know, it doesn't matter the reason why they are there. They are there because they need to be supervised, and they are required to do so for different reasons. So they should count on that 8 number, so that we don't have all of a sudden, you know, 15 people because we have only 8 that they need to pursue license. All the others have been, you know, have the different circumstances of supervision, but they're still adding to the workload of the team. So that's for my understanding, you know, from obviously a perspective that is not of a person. So I want to put it out there if I'm on the right path for, you know, for our licensee here, board members that obviously know more than I do in this. So I'm done with that. So I don't know if anyone else would like to add or share or.
I'm curious a little bit about the history of this bill. What problem is this solving? Like, how did this come to the board? Why do we want to change it?
So it came because there was a question of, you know, of a circumstance where somebody you know, basically called us an ass or emailed us and say, hey, I've got these licensees that I want, you know, to be under supervision, and I want to include them in my supervision group. Do they count against the number?
Okay.
And anyone else, I don't know if John or Wendy has any questions, otherwise we can go out.
What if there was like a max amount of non-licensed people in the group, right? Like no more than 2, right? People that can be supervisors or licensed, and a total amount of 8, right? For people that have cases, and that are there for supervision, right? So that we can maximize like how big the group can become. I don't know if that was clear or not.
That's an interesting possibility. I think, yeah, I'd be interested to hear what stakeholders
think. Okay, let's try that and then we come back to us. Moderator, if you would like please to open to the public and see if there are any comments. Thank you.
Certainly. And we are opening up the WebEx Q&A feature to facilitate public comment. If you'd like to make a comment, you can look for the question mark icon, type the word comment in that text box and click send, or you may raise your hand by clicking on the hand icon, and our call-in users can press *3 to raise their hand. We do have one request for comment from someone logged into WebEx as Ben Caldwell. Ben, I'll send you a request to unmute your microphone, and you will have 2 minutes to speak with a 15-second warning. You're unmuted.
Good afternoon. Thank you. Ben Caldwell, MFT. I appreciate the committee taking this on, and Roseanne for your thorough explanation here. Earlier in my career, I worked in an agency that included an MD, an RN, and several unlicensed support staff in group supervision, or what they called group supervision. And it was basically conflating a treatment team meeting, which is valid and useful, with clinical supervision, which is valid and useful, but should be different. The supervision in that setting was less than it could have been, because while I don't think any rules were being broken, there were so many voices in the room. So I would encourage the committee to do a version of Solution 2, where group supervision is limited to no more than 8 participants, but possibly with a caveat that other licensed mental health professionals, fully licensed folks, would not count against that number. That would allow, for example, one supervisor to observe or be trained by another supervisor. Thank you.
Ben, can I ask you a question? I'm sorry to.
Sure.
Would that be fair to say, though, that this, I agree with you, first of all, but would that be fair to say that those additional, let's say, clinicians, MFD, that they are there just to gain more experience, though, they're not adding to the volume, like they're not bringing their cases, right? But they are just there to even witness the supervision process and get some inputs and so forth, but not bringing their own cases. Is that given it for granted, or how do you feel about that? What is your intake?
I think it's a perfectly reasonable question, and maybe another way to do it would be to limit it to a total of 10 participants or whatever. But there comes a point where it becomes too many words to be useful, and so I think we're looking at a variety of probably imperfect options that all are pretty good. We want to make sure to clarify to the extent possible. There's always a risk, even in a group that is just 8 unlicensed people, that you're going to have 1 or 2 people who dominate the conversation. So at some level, we have to trust the supervisor to manage that group supervision appropriately.
Thank you. Thanks for answering that.
Thank you.
Moderator, are there any other comments before? Abigail, I'm going to finish the public, and then we go back to ask for other questions. I want to make sure we don't jump into, as I did. Make sure, yes. Don't do like I did.
There is one more request for public comment from someone logged into WebEx as Kathy Atkins. Kathy, I'll send you a request to unmute your mic, and you'll have 2 minutes to speak, and you're unmuted.
Thank you. This is Kathy Atkins from CAMP. I appreciate the BBS, Roseanne, for reviewing this. CAMP does get questions from supervisors and agencies requesting whether folks we see it a lot in agencies, who all can be part of that supervision group. I think I'm confusing part 1 and part 2 a little bit, so my apologies if I am. But we are seeking clarity just because we're getting the questions, and in a lack of clarity, what we've essentially told our members or those asking is that if it doesn't say it's not allowed, then it probably is allowed. But if clarity is there, that is helpful. As Ben pointed out, sometimes if you try to be too clear, then it becomes too prescriptive. So we're deferring to the BBS on how best to solve this problem. I guess there's a little bit of a concern that if you have a supervision group that is made up mostly of folks not pursuing license, maybe a couple of college interns, things like that. Is that pre-licensee getting the quality supervision that they need? But I would say we defer to the BBS with your consumer protection directive to be in a better position than us to answer that question. But that's our just kind of top of the cuff thought. Thank you.
Thank you. Thank you so much. Moderator, are there any other?
There are no other requests for comment at this time. Shall I close that public comment feature?
Yes, thank you.
You're welcome.
Abigail. I know you were trying to say something before, right?
No,
Oh.
I think I said what I said. Yeah, and I still stand with, creating limits, right? So that it's a reasonable size group and the majority of the time be spent with people that are reviewing cases, right? And because 8 is already a pretty large group of people. So,
right.
Yeah.
Thank you. Because we do have 8 is the number that's official. The problem is how that 8 number is composed. I do feel that at the moment for the number 2 option might be not too descriptive, too limit, and then create some other issues. But the definition might allow us to have a little bit of flexibility, but not to a point. I heard also what Ben was saying, then all of a sudden you have a team of supervisors that are not clinicians, mental health providers, but they are, doctors, and maybe they're offering their intake about a particular case, but could take away from the benefits of the actual supervisee. So I think option 2 might respond to that. That's how I feel, but I don't know if there are any other from our clinicians as well, if there are any other inputs. Seems like we're good. I am looking at you, John, but
No. I'll put this quick thought out. I think it is like a fine line to look at where this is taking us, because there is a huge difference between treatment team and supervision. Treatment team is based all on what's happening in the organization, what's happening on the floor, what's happening with the patients at that point. Supervision is focused on the growth and development of us as clinicians. And so I think this idea of having a lot of people who may not be pursuing their growth as clinicians, that is going to water down the experience of supervision. Because once again, a treatment team is all about patient care, and supervision is all about clinician development and growth.
So do you feel like any of these 2 options might respond to that, John, or you feel like perhaps we're not even there?
I think it's a rough call, because I lean a little bit towards suggestion 1 with the languaging, because I think that gets closer to creating a little bit more of the purpose of what supervision is for both trainees and associates. I think language 2 leaves a lot of windows open for it to turn into treatment team very easily. And then a question 2, I agree with Abigail. Have we been getting a lot of specific questions about this and there has been a lot of disagreement, or is it just we're trying to catch the horse before it runs out of the corral?
The second option. We've been getting just a few questions. It's not something that I got a question on for a very long time, but recently we had a question pop up, and somebody had asked us, and then Camp wanted some clarification. So, and then I got a couple more questions on it after that. So it's not a huge issue, but I do see it as an issue that where the law could be clearer, so that we have a clear answer when that question is asked.
Roseanne, I wonder if we can, for lack of better words, kind of table things in a way of perhaps even bringing it to the board, and maybe we can strategize a language that's a little bit that doesn't give us some time to create a language that doesn't necessarily fall into 1 or 2, because I do like. I now I see what John was saying about number 1. At the same time, it depends how you read it too, because it could leave the same interpretation open, but definitely stronger than number two. And two could actually resume those settings that they are not, for the formation. The reason why the supervisee is there, gaining their hours and expertise. So I wonder if we could maybe, do we have any deadline on this? Is there anything that we are missing the boat in terms of timing?
Nope, not at all. It's just something that we're in discussion phase right now. It's a question that came up. And so yeah, we can take it to the board if you want to discuss it further. Or
Max, this is John Sovek. Could I actually put a thought in?
Sure.
Perhaps, Roseanne, from our discussion today and hearing, both from our attendees who are involved in the clinical setting and hearing the conversation today, perhaps it's giving you more ideas of how to craft the language, and then we could actually bring that back to here before taking it to the full board.
Sorry. Go ahead, Roseanne, go ahead.
The main thing I heard is to possibly add in something about, a licensee observing will not count. So we could add some language about that in. I don't know how we would, but then the question becomes, how do we define other licensee? Is that just our licensee? So it kind of leads to another question in my mind. I'm not.
Yeah, what I would like to suggest, the only reason why I would like to go to the board, because also I see a lot of the associations missing today. So going to the board doesn't mean that we have to decide that they are, but allow us to gather more feedback, John, about the associations that are usually showing up to our meetings, even the general public that might be less inclined to follow the P&A committee, and gather a little bit more feedback about how big this could be, what the issue that we're addressing. So perhaps that could help us a little bit more. I'm more inclined to go back to a public setting like the meeting instead of coming back just to a P&A, also because the board is coming up, right? We're really close to the next session. Instead, the P&A will be quite further out. So we're postponing this down in the next 3 months.
And I'm going to be that sassy board member you love me being, Max, because this isn't something that is like at the top of our things right now.
Right.
We're heading into legislative periods, and I imagine the board meetings are going to be very full with a lot of stuff. So maybe the reach out is more like, hey, some of you didn't attend today. Here's what we were just send out the actual proposal to these stakeholder organizations and get direct feedback from them to start the process, because it feels really incomplete right now what we're even trying to talk about. And if we have a busy legislative schedule coming up potentially at this first board meeting, I would want to make sure that we as the P&A were presenting something that was ready to actually get really strong direct feedback about.
That's a valid point. I don't even know if we have, if we are within the time frame to add anything to the next board meeting. Steve, is that could be the case, or we're late, right? If we
we can, but it's a really quick turnaround. Honestly, I think because of the way we're at it seems like there's a lot of language changes we could maybe look at. I would probably recommend bringing it back to the next P&A committee, honestly.
Okay, so it's not a quick turnaround because the P&A.
Oh, well, it would be a quick turnaround to get it into the board to the board meeting.
Okay, that's what you meant. Okay,
yeah.
So, but we still have time. Then, yeah, I can agree to that too. So at this point, we don't need to take any actions. Actually, we can just not vote on this. Am I right, Roseanne? Or would that be the right thing to do?
Seeing is
we missed you.
Sorry. What we could do is staff could reach out to the stakeholders, the associations, for suggestions and see if anybody has any suggestions of language that might work for this piece.
Yes, I like that. And that doesn't require a vote either, right? It's a mandate that we are sending to staff that we're sharing with you now. Okay. Wonderful. Then if there are any other things, we can move on from this. I'm trying to scroll down and see all of you. Okay. And we're now moving to agenda item number 6.
Max.
Oh, sorry.
So there was another piece of this discussion.
Oh, right.
It was, do you want to just get feedback from the associations on that as well before we proceed and talk about it at the next meeting?
Well, at this point, that would be, I'm inclined to say yes to that because it's part of the same, I read it, it's part of the same concerns that we had, or I don't know, if other board member feels differently, that we can move on to the second part. You good? Okay.
Thank you.
No, thank you for stopping me before I did some damage. Okay, we're moving now to item number 6, which is the discussion and possible recommendation regarding legal name changes and website posting. Roseanne, again, thank you for introducing this.
Thanks, Max. So when a licensee or registrant applies to the board, the applicant must provide their legal name. And that's the name under which their license is issued and under which the person may be searched for on the BREEZE online license verification system. And the law, which is in Business and Professions Code 27, requires the board to post specific public information online via BREEZE. And that includes each licensee's status, their disciplinary actions, and their address of record. If a licensee or registrant changes their legal name, then there's a procedure set forth in the board's licensing laws that they must follow. And so what that is that within 30 days of the issuance of their new government issued photo ID, which is usually a driver's license or passport, they would provide written notice to the board of the name change, providing both the old and the new names. They would need to include a copy of the current issued government photo ID and the legal document authorizing the name change. So that might be a court order or a marriage certificate. And then they would need to certify the information by signing under penalty of perjury. And I've included in the packet a link to what the board's name change form looks like. So typically when a name is changed, the board will update the BREEZE system to include both the old and the new name. If a member of the public searches for a licensee under their old name, then the old name is comes up with a notation that it is a previous name. And then if the more detail option on the side, on the right-hand side is selected, it leads to a page which has the license number, the new correct name, what the previous name is, and then any public information available about the licensee. If a member of the public searches the current name, then the current name comes up with the record. And if more detail is selected on the right-hand side of the page, it leads to a page with the license number, the current name, the previous name, and then any other publicly available information about the person. So we've been asked to look at this topic because at times there might be times when a licensee might legally change their name in order to conform their name to their gender identity. And there is a legal proceeding to do this, and I've included a link. It's in the civil code of what the legal procedure to do that is. And when this is done, the previous name is commonly referred to as a dead name. And so the person may prefer that their previous name or their dead name not be listed publicly on the BREEZE license lookup. And so this has led to a question across DCA about what to do when this particular instance happens. The law does not specifically require that the licensed previous name be disclosed. It's silent on the matter, but the DCA has always encouraged that it be shown so that the public can search. If they only have a previous name, then they can find the person under their new record and move forward. So within BREEZE, it is possible for an old name to be designated as private in the online lookup system, but if it is designated as private, it won't appear in a public BREEZE search. However, the old name would still likely need to be disclosed if requested due to the public nature of the information, like if it got a public records act request. So in doing a little bit more research on is there any other agencies that have done anything about this? We were directed to the State Bar of California, which regulates attorneys, because we were told that they had come up with kind of a workaround on this. So Steve and I met with the person in charge of licensing records at the State Bar. And so what their policy they came up with, which actually was not through any statute or regulations, is what they do is if somebody searches a name on their website to look up an attorney and they type in an exact name that is a dead name, then instead of any information coming up, their website prompts the searcher to call their office for more information. So when the person calls, then the consumer that's trying to find that licensee is then given the new name information, their correct name, and then they are able to move on with their search. So that's what they have come to. Although in consulting with DCA Legal, they have a few recommendations about that. It would need to be done via regulations, and they also would suggested that we consider that we consider other groups rather than just people who have dead names, for other reasons, because there are some legal implications of that being equal under the law. That's what they recommended if we were to consider forward with that alternative. So DCA Legal went in their conversation, it sounds like the best possible solution would be that legislation be introduced at the legislature to create uniformity and clarity across DCA boards on how to address this for everybody that was the same policy. And I know that there has been conversations at DCA with the legislature. I have not seen any language introduced yet on the matter. So I don't know. We're just in the process of bills starting to be introduced. So there could be something introduced this year, but I'm not sure. So legal pointed out just to be aware of the consumer protection interests to balance against the interests of the licensee. And should the board seek to advance a policy before legislation is developed, that we should consider the policy, if it develops around dead names, should also include options available to others who change their names for other reasons to avoid discriminatory claims. So that was the feedback that I got there. So we just wanted to start the discussion and kind of see where it could lead and go from there. I'll turn it over to you, Max.
Yes, thank you. And I'm going to take advantage to throw some conversation in there. One of my, first of all, as an agency that is paying attention to consumer protections, we also had to take in consideration as we do so we don't cause any harm on doing so, right? Because well, number one, I think it's time. I'm glad that the agency is looking into ways how to honor the people that have been changing names and gender and sex assigned at birth on certificates. And the state of California, by the way, as a reminder, because I'm not expecting everyone to know that, once a person changed their name and record and sex assigned at birth on their birth certificate, the state of California deletes forever all those records. What that means, for translating that, if I'm a trans individual that has changed name and gender, and I decide to go all the way back to my birth certificate and change the sex assigned at birth, which is totally legal in California, the state of California will guarantee me that no one will have the opportunity to dig back into my records and find I was male or female or non-binary or whatever the circumstances are. So I would just want to give that scenario, because definitely we don't want the BBS to create, in trying to help folks and also put in place consumer protections, we don't want exposed to people to the possibility that could their dead name could come out and could be disclosing the individual gender identity of sex assigned at birth in order to provide the information that it's needed for consumer protection. So I'm trying to find a way where, for instance, I'm just giving an example, for those people that don't have any records, right? For those of us that are clinicians, they don't have a record of being under BBS rules, or there are no conditions pending on their license. So these are just good folks that happen to change their name and sex assigned at birth in order to start their own life. Now all of a sudden, just because of consumer protection, because we know there are circumstances where, let's say, that person causes malpractice, someone is going to sue them 2 years after, and now 2 years after that person goes another name. According to the consumer protection, they are supposed, obviously, to go back and be able to find that person. And the way they can find it is by digging into their, they had to call in and then finding that name, that person actually is being, is no longer Mario, buys Maria, whatever the circumstances are. I find it we're navigating to be very careful, because the state of California goes to the extent to protect our individuals in a way that there's a full protection. So no one should have the right to go back and dig out personal information around their gender identity, sex assigned at birth, especially also when they have they had no pending issues with their license. So it will be a total violations. And also in regards to, can we apply this to just certain populations versus others? I would say the element here is not just like privacy, but it's safety. So any other person that changes their name because they don't like their name, or because, they become this, or in terms of like a name, there is not an element of safety. If me as a cisgender gay person, I want to change from Max to Mario, even if you end up finding out that my previous name is Max, it's not going to jeopardize my safety. But for a trans individual, in the data nowadays and how they are discriminated still at work, on the violence in our community and society, being able to be outed as a trans individual, now there is an element of safety. It's not just about consumer protection. So in order to protect the consumer, now you're outing someone, it potentially put them at risk of safety. So to me, that's for lack of a better word, is the element that will distinguish protecting trans and non-binary people from any other populations that is changing their name just because they don't like their name, or it's associated with a family history that's brings bad memories. Whatever the circumstances are, there are millions. But if the element of safety is not the element that where people are running away from, literally, then it shouldn't be a problem for us to look at the license as their social security of our individuals, and look at the license number to identify people, the wrongdoing in relations to bring them back to, justice, right? If someone has done something wrong, there is the license number never changes, even though the name has changed. So I think if there is a way for us to focus on the license number versus the name, which comes with gender, will be a better way for us to protect the consumer, but also not to put at risk a population that has already been exposed, especially in the mental health environment, has always been the most stigmatized and marginalized as well. So I don't know, I hope I didn't put too much into it, but I think this is really a big issue that's been brought to us several times, where people want to change their name, start a new profession with a new clinic perhaps, and not having to disclose to anyone that does search on the internet about their name and their past and so forth. So and I leave it in there. Sorry for being so. It's any comments from my fellow board members? Oh, I see Wendy. Sorry.
Yeah, I was kind of considering the scenario that you just went over and how to balance those two factors of the safety of the clinician and the consumer's ability to file a complaint. So I mean, maybe your solution of complaints proceeding under the license number and not really and not naming. I mean, is there a way to process the complaint with a license number and not really under a name, I guess? I'll leave that off.
I think that not the problem, but the issue is the public records request. So any accusation or any any administrative action that's taken against a license has to be published. So even if we were able to get it just to under the license, that document would still be possibly, if we took action under an old name, it would be, it would have to be, I believe, retrievable by the public. And so they could, if they wanted to, kind of seek that out. So there's really no way we can completely, we're just starting to talk about this. So trying to figure out how we can do that. But there's no way right now I can think of where we can completely seal those records to protect the clinician.
So, thank you,
Steve. This is John Sovak. Would we need to seal those records, or in the process of a name change, wouldn't the records already be sealed?
No, because just like what currently happens right now is if the name is changed, it links up. You have to link the license so that you can be able to track down, the actual licensee. The part of the public protection too is not necessarily. I think the other part of it is making sure that that client can be able to access their records later on. Let's say if their relationship with the clinician is over, and then a couple of years from then they need to get in touch with the clinician to get their records and stuff. They need to be able to figure out how to get in contact with that clinician. I don't know how we could get past that if we just rely on that the clinician has to figure it out with their old clients how they want to address that. If maybe that's not really necessarily within our purview. The one crux I keep thinking about is there's really no way we can, and I mean Sabina might chime in on this. I don't think there's any way we can really seal those records. The administrative, like if we've taken an action on somebody, beyond that, I don't know with the license number, kind of what the bar is doing. I can see that's a little bit better. We could probably hide. I'm sure we do have the ability in Breeze to, hide a name, and then if somebody really needed to get in touch with a clinician who has a dead name, we could actually, work with them to kind of connect them together. So I don't know. It's complicated. So
Steve, my question is, and thank you for that clarification. So we had obviously, if we have a clinicians which with a past, right? In terms of like there is a board of behavioral science, maybe they need to do supervision, like a period of suspension, for instance, or revocation or whatever it is. Then obviously, because those documents are public to the record, like you said, there's nothing we can do. I mean, if you have something against your license, people need to have the right to know what is that thing against your license. So even if you change your name, people are able to see that actually that person was going by a different name and gender, 2 years prior. I think that obviously it's even outside our jurisdictions, to be honest, right? Because at a certain point, people have to have access. But for the majority of our clinicians, for those that don't have a pending circumstances against their license, we want to reduce the impact of exposing them to possible, right? So I think we adopt something that, for public record is public record. So we can't change that. It's not even our jurisdiction. But for everyone else, I don't know if, again, even if I have a complaint against a person with a first name and last name, in order to really know that that person is the person I need to go against it, I need the license number, right? So if I had to file a complaint, a name and last name shouldn't be just enough because I need to have their place of work, the license number to make sure we're addressing the right person because a lot of people have the same name. So I find that we just have to find a way. I don't know the answer how we breathe so ourselves we can legislate in a way that we don't expose people that the state of California is fully protecting under the law. I mean, there are people getting sued for adding folks for their, past as a different sex or gender. And now we open the door for people to do a search or even to investigate unless they have the reason to do that. And also, as you know, everyone that makes a complaints against a licensee doesn't mean that it's valid. So now we're outing someone with the risk of possible even violence when maybe that complaint wasn't even valid because it has to be investigated. So we got to look in a way because I honestly, the law, I mean, this is new enough to understand that a lot of institutions have actually not cared about our trans people for many, many years. So I don't know, and even though I appreciate reaching out, you and Roseanne reaching out to other institutions to see what they did, right? But doesn't mean that they have the solution because at a certain point they haven't really, understood exactly the level of exposure that could cause to an individual and even really in terms of their safety. So I wonder how we can find a way that satisfies consumer protections, but also protects people because then.
Well, and Max, could I step in? This is John Sovak. I have a thought. Roseanne, I think it's great that we're reaching out to other agencies. I think this is definitely almost a DCA-wide consortium question to try and create policies. But the thing that I'm realizing as we're talking around here, the knowledge I have, the people who are attending this meeting, we are all cisgender. I believe if we're going to try and create policy and procedure on this, in the conversation, we need to make sure include transgender people so that they can also bring up needs that we may not be aware of that they're finding in their daily life. It might be reaching out to some of the academic associations. It might be looking at some of the LGBTQ centers that have legal resources to try and always get input from the community itself rather than us well-meaning cisgender people trying to create policy in response to a need that's being addressed.
Very, very good point, John. Thank you. My personal stand also is that by being an agency that's LGBT and we have legal teams in regards to this, and we do name change, we see the impact every day. So that's why I'm passionate about it. I totally agree with you, perhaps.
Right. And I think that's where they're reaching out to organizations such as yours all over the state, working with their legal teams to find out what are some of the intricacies that we may not be aware of that would actually help to create the movement for this policy. Because I think us sitting outside a system and coming up with all these ideas is a good start, but we also need to have the community itself giving us feedback on, oh, this is the thing that happens every time we try and change our name in different professional environments. This would help us. Is there a way to create policy around that? I think that's actually a big step in us trying to create something with this. And I hate to do this, but I know I let Max know ahead of time. I do need to step away. I've got a clinical thing I have to manage in a few minutes. I'll check in when I'm done. If y'all are still on, I'll come join you again. But thank you all so much. And Roseanne, thank you for bringing this to our attention too. I think it's such a powerful thing we need to address.
Thank you, John.
Bye, y'all.
Roseanne, if you don't mind I can send you the point of contact for Transgender Law Center, which is a very powerful institution that's very well known and also address issues that has to do with consumers and legal in general. So Trans Law Center. And any other comments from the board, and then we can go into the public.
Can I really quick?
Yes.
Really quick. Yeah, John was right. I mean, it's a really big policy. There's two things I think that are really the crux of this. It's looking at the overarching, which is kind of a bigger than just the board here, the overall policy of what we have to post on the internet, what needs to go out there. That's the policy decision that I think needs to be made. And then the harder part where we have to look at, we're contacting the law groups and maybe some of the agencies, is looking at that public records and what we can do to kind of, if there's anything we can do to, not hide those away, but can't think of the proper term now. But yeah, if there's any way we can keep those public records, if somebody changes their name, keep those sealed. But I think one of the things we will have to do is it definitely has to be it would have to be equitable across all licensees and protected classes. So, but that's something we can definitely work out. I think the bigger, not the easier thing to tackle first is the policy decision about what to post on the web. So maybe that's kind of a focus.
I see Sabina. Thank you, Steve. I see Sabina would like to say something, I guess. Our legal counsel, Sabina. Hi.
Thank you. Can you hear me?
Yes. We don't see you, but we hear you.
Oh, that's okay. You don't need to see me.
Okay.
Yeah, this is wonderful discussion. And I know I spent, Roseanne and I have been going back and forth. I've also been reaching out to other boards to see what they're doing when they get such requests. It's definitely a DCA-wide matter, as you well know, and we have to treat all licensees.
Sabina, I think we lost you. Oh, Sabina? Anyone can reach out to Sabina, I can text her.
Agreed. This is the moderator, Ann Fisher. She still appears in the meeting, but yes, the sound cut out completely.
I'm texting her. Well, yeah, she just responded to me. So let me see if she's. Oh, she said, hold on, everyone, just a second. Okay, she said to move on and that she can add something later on if we're still on this item. She has some problems with power. She says she's struggling with power, electric power. Okay, then any other comments from the board before we go to the public? Any observations? This is, as a reminder, there is not a motion for this. We're just starting the conversation. Okay, moderator, can you please go to the public, please? Thank you.
Certainly, and we are opening up the WebEx Q&A feature to facilitate public comment. If you'd like to make a comment on this topic, you can look for the question mark icon in the lower right corner of your WebEx screen. Type the word comment into the text box and click send. The other option is to raise your hand, which people are already doing, to indicate that you'd like to make a comment. And our call-in users can press *3 to raise their hand. Each commenter will have 2 minutes to speak. And the first comment request was from someone logged into WebEx as Elaine Montgomery. Elaine, I'm going to send you a request to unmute yourself, and you can have 2 minutes to speak. You're unmuted.
Hi, everyone. This is Alon Montgomery. I'm a staff attorney with CAMT, and I just wanted to say thank you, first of all, for initiating this discussion. We so much appreciate it, as we've had a lot of comments and input from LMFTs and CAMT members who are part of the transgender community who have raised this issue. We are looking forward to working with coalitions and advocates who are comprised of, or who comprise psychologists and psychiatrists on this matter. So we are currently doing our research, reaching out to others who may be involved, and we are definitely looking forward to working with the board as well as the Department of Consumer Affairs and the legislature on this matter in the future. Thank you very much.
Thank you.
And we do have one more request for comment. This is from Ben Caldwell. And Ben, I'm going to send you a request to unmute, and you will have 2 minutes to speak. You're unmuted.
Thank you. Ben Caldwell, MFT. Seconding what Alon said, I just want to thank the board for taking up this issue and for taking such a good, thoughtful approach to it. As Steve had mentioned, it sounded like Sabina was headed in this direction as well. It would be better, it'd be ideal to have DCA set a consistent standard that goes across DCA boards and bureaus. And as John had said, to do that in collaboration with the trans community. Otherwise, the risk here is that you might have dozens of DCA boards and bureaus that each go through their own kind of policy making on this and wind up at a whole bunch of different inconsistent processes. So I appreciate you taking a thoughtful approach, working with other boards and bureaus, and really finding a solution that best balances all the different needs and interests here. Thank you.
Hi, this is Christy Shields. Can you hear me?
Yes.
Yes. Hi, Christy.
Hi, I've had my hand up and I wasn't sure if you saw it, but
No,
my
I
name is
didn't. So
Christy
sorry.
Shields. Let me see if I can.
You are in. If you.
Video, can you see me?
Yes. Now we.
Hi.
Yes. Hi.
Hi. Hi, my name is Christy Shields. I'm an attorney with the Department of Consumer Affairs, Legal Affairs Division, Regulatory Review Unit. So I was asked to attend this meeting today to cover regulations issues for the board. But Sabina's been put temporarily out of commission. So she said I could go ahead and chime in on this item while she's getting reconnected. I've been with the department since I was board counsel for this board for a period of time, so I have some experience in this area. And, you know, from a regulatory perspective, I think it'd be very difficult for you to be able to pass a regulation dealing with this concept for two reasons. One is the Business and Professions Code Section 27 that was referenced previously, but also the state of California has enacted a sunshine law, so there's a constitutional right for people of the state of California to have access to public records. And so I think that trying to craft rules or regulations that would run potentially contrary to the Public Records Act or the Sunshine Law, because they have a constitutional right to the information we have that's not otherwise exempt under current law. So I think that exploring some sort of a legislative proposal that balances the two policies, one to privacy and safety, as previously mentioned, and the other to this constitutional right of public access, is really something that you would probably want to focus on, because you have to get past that constitutional access issue in accordance with the Constitution, which lays out the parameters for how you would keep something sealed or private from the public and under what conditions. So that constitutional amendment actually does talk about what kind of legislation you would need to overcome that sunshine law that was enacted around, I think, 2004. So that is something that you probably want to think about going forward. But I think the idea of doing any kind of a rule that the BBS could potentially adopt, it really could run into problems because of that constitutional provision and BPC section, Business and Professions Code section 27. So like I just said, I don't mean to step on anyone's toes, but I wanted you to have that information. And I know Sabina said she can't connect right now. She said to go ahead and give it. So if you have any questions about what I said, please let me know.
Thank you, Christy. I would like to get back to that in a second. I have a question for you, but before I do so, I want to see if there are any other comments from the moderator. And
Yes.
Thank you.
Thank you. Yes, there is one other person with their hand raised. I'm going to send a request to Tricia Wallace. And Tricia, you will have 2 minutes to speak once you get started. You're unmuted.
Can you hear me?
Yes.
Wonderful. Thank you.
You're welcome.
So I really appreciate the Board of Behavioral Sciences. Dr. Tricia Wallace, I'm a psychologist and a licensed clinical social worker. I am really grateful to the board for bringing this up and discussing. This is an issue that is a DCA-wide issue in that I've been working with and have colleagues who are trans. I myself am cisgender, but I am queer and part of the LGBT community. And my trans colleagues, both MFTs, social workers, and psychologists, and we do also have one medical doctor. We all have examples of each of them, but they also wish to remain anonymous. Have been telling me the stories of how this current practice is impacting their life. And I just, to be able to give this some human perspective, and although not speaking for them, but just to round out that perspective, the cost associated with being dead named, many of them talk about how, sometimes they've had patients ghost them after doing a license lookup. I have one where they treat patients and clients that are in a place that they're sort of like not court ordered, but court encouraged to do treatment, and they'll find out the person's dead name and then try to use that as leverage to get out of the treatment. Like, I know your little secret, I can out you, etc. Also, when going for promotions or applying for new credentialing, having to list your license information and then the place where you are getting credentialed sees your dead name. It's a constant source of stress for many of these individuals. It's not only a microaggression, but a macroaggression. And so I want to say that once again, social workers are amazing. And because the social work board is taking a look at this, I really want to applaud that for social change.
15 seconds.
And also, I just want to talk about the element of time that once this is on there and dead named, it's forever. So we have someone who's been licensed for many, many years who's still on there. So again, thank you. And I look forward to continuing this work.
Thank you. Anyone else?
Let's see, we do have one more request. Someone who's logged into WebEx is under the name Rebecca Gonzalez. Rebecca, I'm going to send you a request to unmute yourself, and you can press *6 to unmute yourself if you are on a dial-in. You're unmuted.
Oh, can you hear me?
Yes.
Yes.
Oh, good. I couldn't be unmuted. Yes, Rebecca Gonzalez with the National Association of Social Workers California chapter. Like the other callers, I'm so happy you're talking about this issue. I am very pleased to see the concern from the board about this very important public safety matter. And I'm really glad Trish called in, because I was waiting for her to call in, because I wanted to hear from the person who really first brought this issue to our attention at NASW California, and we really did need to have somebody from the community and have their voice. I also wanted to point out that I do think this could be a public safety issue for certain domestic violence victims. So it could go beyond the community that we're talking about, and I agree with everyone else that this should be system-wide. As I believe the representative from CAMP said, we are working with the other professional associations on legislation, but we want to carefully craft it. I really appreciate the comments about the Sunshine Law and taking that into account, but I think it's very important to protect the safety of the people that we're talking about. Thank you so much.
Thank you, Rebecca. Is there anyone else?
No, that is the end of the request for public comment. Shall I close the public comment feature?
Yes, thank you. Thank you,
You're
moderator.
welcome.
I appreciate everyone. I don't mean now to draw any conclusions because we just started this conversation. And thank you, Christy, for intervening. Sorry, I couldn't pronounce your last name. To give us...
Shield.
Thank
Shield.
you. Shield. Thank you so much. I was aware of the Sunshine Law, actually. Well, I run an agency also does a lot of advocacy. We serve thousands of LGBT people and trans people in particular. I had to say, though, that is paramount, obviously, because it's a constitutional rights. But when the non-binary, 5 years ago, the non-binary and the sex assigned changes that can be permanently done to the birth certificate of individual that happen to be transgender non-binary cannot be resumed for any reason by the public, but just by institutions, let's say FBI investigations and so forth, because of safety that proceeds And I don't want to even attempt to use the legal language because I'm not a scholar whatsoever. But I know from the advocacy standpoint of view, we were able to protect fully under the state of California, unless there are investigations, attempted investigations by state officials, right? You know, like old federal one, like the FBI and so forth, for whatever reason. But for access to the public, when safety is the element of jeopardy for people's safety, and not only how that makes them feel, that actually has to be taken in consideration. That was actually one of the reasons why a trans person that can change their name in California and their sex from their birth certificate, no one will have access to their original birth certificate when they were actually born assigned, I don't know, male at birth. So unless, you know, some institutions had to do that, again, for whatever reason, but there is not, usually hasn't been found one. So I invite everyone not to postpone this to, I agree, it's a DSA issue, because then you don't want to have a rule that affects one part of that here with the BBS and another that opens the window to possible, right, challenges, legal challenges. But I had to say that if I was a trans individual and I know that the state of California fully protects me, and then I have no reason to have to, and my license hasn't been affected in any ways by any discipline, and all of a sudden someone does a search and finds out through the breeze I'm actually a trans person, and it causes the consequences at work or safety. I mean, we live in a world where people are actually going outside of folks just for being openly trans on their homes and their residence and their workplace. I can see that a lawsuit coming. So we also have to think about the possible, what we're doing and how we can prevent any possible harm. But nobody wants that, of course, and how we can advocate for DCA to really look a little bit deeper about this, so that we're not going to be the only agency that is going to jeopardize the safety of trans people, that there are clinicians when they had not committed anything that will allow us to put anything on their license, right? If there is not investigation, I'm talking about cases of people which license is not in jeopardy whatsoever, and they are not in probation, but they are just therapists that happen to be trans. I want to make sure that we protect those in premise, so that no one has the right to do that. And then I can see you, Christina. Definitely. Go ahead.
Okay, this is Christy Shields again. So I just wanted, Sabina reminded me of the fact that there's a lot of issues that need to be addressed, not just California's requirements that we have for posting and providing information. Because remember, we are responding to Section 27 of the Business and Professions Code's legal mandates, which we've always viewed in our office as sort of like an informal public records request. When someone types someone's name into our database, that's a PRA, and people pull up that information to make it readily accessible to the public under that section of the law. We provide that information. So that is one piece of it. But there's also other pieces, like the fact that we have to report to the National Practitioner Data Bank. That's a federal law. How are we going to work that through whatever policy decision California makes? It may not actually address the bigger picture, which other areas of disclosure that happen where people could link people's identities through other means. So I think this is more global issue than perhaps at first glance we think it's just a website issue, but it's actually a larger constitutional and federal issue that I think needs a broader approach than perhaps the board can do under its current jurisdiction. I'm not saying it's not something you should continue to discuss, but you should be aware that some of the legal limitations would have to be first dealt with, but you'd want to, continue to discuss the policy issues, at will, but consider the fact that there are these other laws that affect these privacy issues you're discussing that would also have to be addressed as well.
Okay, thank you so much. And I believe I missed my fellow board member, Abigail. I saw you with your hands raised. I don't know if it was an old one or a new one. It's a new one.
Yes, I did have my hand up. So, it seems in listening to Christy, I put my hand down because I was like, oh no, this is much bigger conversation. I definitely don't have the answer, but in listening, um, I just hear like for cases that are deemed sensitive, right? That we don't want to just hand over the name on a website. That we create like a series of like firewalls, right? Like the first one could be call this number or fill out this request, and that we just become more thorough in our process. Um, Before we just hand it over for safety reasons, um, and that we that we really know why people want this information. And I don't know if we're allowed to even ask why, Christy, or if we just have to hand it over at certain point. But that just came up for me as like firewalls before we share. Mhm.
I mean, my recommendation would be to seek amendments that would correspond to what you're talking about, because right now it says we have to post the name, their legal name, and all their identification. That the only thing they're allowed to do to protect their safety is to give us a PO box in lieu of a physical address, so people can't physically locate them. So if you're practicing in a facility, you don't want everyone to know where that facility is, you would just give your PO box in association with your name, so that the only people that would be able to find you would be the people that you're directly working with. So that's the only privacy protection the legislature built into that section of the code. So yeah, making changes like that the state bar has done. And again, the state bar is not a state agency like we are. They're actually part of the judicial branch. They're not in the executive branch of government. So we are subjected to more rigorous public disclosure requirements than they are, because they're part of the courts. We're not. We're part of the executive branch of government. And we have to comply with those requirements in Section 27 as written until somebody decides to make those changes. So I think that you could look at exploring changes to that section of the law. And I think that's why I was talking about that maybe these policy issues should be in a greater forum, so that there's more consistency across the department and all the other agencies that are subject to the Business and Professions Code. It's not just the department that it would be affecting. Department of Real Estate would be affected. Other executive branch agencies would also be affected. So we need to bring all of those players to the table and have these discussions and come to some kind of consensus about how we'd want to try to protect while balancing the public protection mission, which is all of our mandates. Public protection is the highest priority. So those things you probably want to work on, maybe, legislatively. I don't think that you could approach it from a policy or a regulatory perspective and not run afoul of Section 27 or even the Constitutional or Public Records Act mandates that we're all subjected to. I mean, I've been involved with Public Records Act litigation. That's a possibility. If you tell them you can't get it right away, you have to call a number. I'd be concerned about them saying, well, wait a minute, other people get ready access. Why can't I? And I mean, there's competing interests. So I think we want to ask the legislature to make the call on which side they want that to fall and how they want that to look, so that we're protected from liability under the Public Records Act and other laws as well. Someone could have a constitutional claim against you for sunshine law issues. So to protect yourself and have consistency in treatment across professions, I think a Section 27 at a minimum would be a place to start. Amendments would be in order. Regulations aren't going to do it. I don't know you'll be able to get it through the Office of Administrative Law in light of the Constitution and other laws that could be conflicting with it.
Thank you again, Christy. And I believe the intent of reaching out from us, Steve and Roseanne, to other entities was also to see who else has done anything in regards and what kind of things that put in place that were into limiting, but they were definitely a step forward though to do no harm, right? Because right now, I had to tell you, I employ 7 therapists at all trans. And trust me, the level of safety, even for the space where I operate, and I am in California, not even in, in a region, in a desert, in a disconnected area, is quite troubling. So I think a lot of those therapists are seeking for ways to how we can reduce the possible harm that we're actually doing without, even though it's not voluntary harm, it's not, so I appreciate your considerations and also your expertise on this, because definitely helps tremendously. And I do agree with you. It's a legislative effort that's bigger than us. And I know a lot of organizations that are moving in that direction and doing a lot of advocacy to bring those changes that, so let's see what is the room that we can operate within so that we can go to the extent of what we're allowed to do in our jurisdiction to avoid or to reduce the impact, whatever that looks like, right? And I think that will be your help and support in this already has been great. So I hope we can continue to do so when we go to the, we bring this conversation to the board and to more public. So. And with that, I think we are good since we don't have a vote on this, obviously. I would like to move forward to our next agenda item, if everybody is okay. I look at the faces, everything is good. So we're moving now to agenda item number 7, which is discussion and possible recommendation regarding clarification to licensed educational psychologist requirement. Experience equivalent to the 3 years full-time experience as credential school psychologist. And I believe this is still you, Roseanne. Sorry, I need to open my introducing this.
This is actually going to be Christy.
Christy, there you go. Thank you, Christy.
Hi there, Christy Berger, regulatory analyst for the board. So this agenda item is in regards to the experience required to become a licensed educational psychologist. These are the only applicants under the board's purview that are required to have a total of 3 years of experience to qualify for licensure. Our other professions have to have 2. However, they don't have a specific number of hours that are specified, but it does have to be 3 years of full-time. So quite a lot in comparison. A lot of differences, really. So I'll be going over, and luckily it's not as complicated as our other professions, so that's kind of nice. So right now, of those 3 years, 2 of those years have to be full-time experience as a credentialed school psychologist in a school setting. There are no supervision required by the board for those 2 years. So because they're in a school setting, there's supervision. It's just not board specified. And, the type of supervision, is up to the school or the district where they work. So that's 2 years unsupervised at having their credential. And then they have to have an additional year in what I've called category B or C. So category B is 1 year of supervised experience in an accredited school psychology degree program. And while our law doesn't specify who must supervise this experience, the California Commission on Teacher Credentialing, who is the agency that provides for the credential, they require at least 1,650 hours within the degree program that's supervised by a credentialed school psychologist who has at least 3 years of experience themselves. So the CTC does specify that supervision. So if the person doesn't have this 1 year of supervised experience in an accredited school psychology program, instead what they have to have is an additional year of full-time experience, again, as a credentialed school psychologist, similar to that first category. And the law says under the direction of an LEP or a licensed psychologist. So that's in our law. And this also has to take place in a school setting. So again, everybody has to have category A, which is at 2 years, full-time credentialed school psychologist in a school, and 2 years, and 1 additional year either supervised in an accredited school psychology degree program or that year with your credential under the direction of an LEP or school psychologist in the schools. So we have not really done much with our LEP law. There hasn't been any public protection issues brought into our awareness about these requirements. But given, you know, we do like to take a look at this, and also given, you know, some of the challenges in our, you know, mental health professional shortages. And we've been sort of also gathering as we go along if there's any issues that come up to us from our licensing evaluators. So there are some things today that I think will help us kind of see where we need to make some minor changes and maybe even some little bit of bigger changes, nothing too earth shattering, that will, you know, maybe modernize this law a little and make it a little more clear. So there are some minor changes just to improve readability and provide some clarification. So I won't get into those specifics, but it is shown in attachment B. We want to formalize the required documentation of experience. That's just good practice that we want to have that in our regulations. And it's just reiterating what is on our experience verification forms. One of the bigger topics for discussion today is that the statute, the Business and Professions Code, says that the experience for categories A and C need to be in a public school. However, our regulations state that the board may use its discretion to accept experience in a private or parochial school instead. But the regulations don't define how the board should apply its discretion. So in talking with staff, we only get a few phone calls a year from potential applicants inquiring about experience gained in a private or parochial school, but we felt that given the shortages out there, that we should consider a process by which equivalency can be determined. And the proposal, I spoke with Chris Jones, our LEP board member, as I was working on this, and also worked with staff and management coming up with, and our licensing staff as well. So the process that we kind of came to that we think would work best is because, you know, a private or parochial school there were some concerns because they are not like a public school has to follow all the laws about providing accommodations to students. A private school does not. So they don't have those same legal responsibilities to students with disabilities. So there were some concerns along those lines. Now, if a private or parochial school is employing a school psychologist, they probably are doing at least some of the right things and trying to accommodate those students. But what we thought would be a good way to evaluate people with that experience is to have an LEP subject matter expert that the board contracts with when we get an applicant, and have the applicant submit their signed duty statement and then compare what's in their duty statement to the core tasks that are authorized by the Commission on Teacher Credentialing for those with a school psychologist credential. So I've listed what those tasks are listed by the CTC. I tried to look for any job announcements or descriptions that were put out by a private or parochial school. I wasn't able to locate any. So, but you know, they're out there, and if somebody's had that experience, they'll have a job description. So I have provided that language for doing that. So I want to stop there and see if there's any feedback on that process.
Thank you so much. Thank you, Christy. Sure. And then thank you for all the research. This is amazing. It's really, really helpful. I would like to see, sorry, I'm having a problem with my computer. Trying to see the faces of my colleagues. If there are any questions, any observation from the board in regards to this item. I know this has been quite some time, right, Krista, we started doing this.
Right.
I mean, it went back and forth, if I recall correctly, between the PNA and then the board and back to the PNA, right?
We had a proposal, I think it was like 2018 or something. We had started looking at it, and then it got sort of backburnered. So we're back, and it's bigger than it's now kind of grown. So
I can see it became such a definitely there is a lot in it.
yeah, for sure.
Let me go to the at the end. If there is any possible recommendation, I'm having a problem to open this file for some reason on my computer. But any possible recommendations will be just to continue the discussion, because at the moment we don't have any direct items, right? Or just go ahead.
Yeah, we could go through the entire thing and then take discussion at the end, and public stakeholder feedback if you prefer. I'm fine with it either way. So I know it's kind of complicated with the online meetings to go back and forth.
No, it's okay. We do what we had to do just to facilitate the conversation. It's not a problem. So unless there are other questions from our folks on the board, otherwise let me open to the public and see if there are any other feedback. Moderator, thank you so much for helping us.
You're welcome. So we've opened up the WebEx Q&A feature to facilitate public comment. If you've got a comment on this issue, you can look for the question mark icon in the lower right corner of your WebEx screen. In that little text box, type the word comment and send, or you can raise your hand by clicking on the hand icon, and our dial-in users can use *3 to raise their hand. Each person will have 2 minutes to speak.
Thank you.
And I do not see any requests for comment. Shall I close the public comment feature?
Yes.
Thank you.
Alrighty. Question.
Oh,
sure.
Abigail, yes.
Yeah, I see that it says that the board would have an LEP subject matter expert. So we would just have like one expert. We wouldn't have like a subcommittee of experts, just so that we can have a more diverse, right, perspective. It sounds like it would come down to one person.
We could, I don't think it would be anything too complicated to compare those tasks, but we could potentially, we could talk about maybe having more than one person look at it.
Usually in these situations, we'll have one individual because it's really matching. It'll be looking at certain requirements and just seeing if it actually fits within those and addresses those requirements. So it's more of a checkoff list. So what we would usually do in this situation, if we move forward with this, is probably recruit as many, a couple, well, not as many as possible, but a few LEPs that would be able to do this. And then through the process, what we do too on the staff end is after we get the evaluation back from them, we would look at that and kind of make sure that it's appropriate and they're doing a good job. And we would look for quality in those, in those evaluations to make sure that they're appropriate. So if that helps out, Penny, I don't know.
Yeah, no, that does. And then did we like reach out to private schools to get their job announcement or descriptions, or we just looked online?
I just looked online. I haven't reached out to any private schools. I don't know which ones provide accommodations to their students. I wasn't sure how to really find that. So, but that's something I can do if we, because I'm not sure, that this is in its final form yet here. We have a lot more to talk about. So that is something I could try. I feel like it's hard to know where to start, but it's something that, we could certainly give it a try.
Yeah, those were my curiosities. I'm
sure
learning as I go as well.
Yeah. All right.
And I guess for me, I would really rely on the subject matter expert and the experience of the LEP clinicians. It's not an area in the kind of detail we're talking about what supervision looks like and what supervision, or what supervision looks like, and then the equivalents in the private or parochial schools, equivalent experience. I would definitely look towards some suggestions on that from even our LEP board member.
Yes, he was part of this development of this language and this process that we came up with. So, and it really would just be comparing these core tasks that the CTC sets out for school psychologists with the person's job description. So I don't think would be anything too complicated. But it's more than staff could do. It's not something we felt confident that you really do need somebody that is in the profession to do that.
Right. And Chrissy, just for clarification, so would you suggest, would be better for the board at this point to go a little bit deeper about that, or perhaps we can already move a motion that could go in that direction? What will facilitate this work? I want to make sure that we don't slow down the progress he already made on this, and how will be a better approach.
I think at the end, if we feel like this is ready to move on, we could talk about that then, but I honestly think we may have to do 2 shots at this. I'm also not sure if the California Association of School Psychologists representative is here. I saw she was at the meeting this morning. I'm hoping to get some feedback there as well. So, but let's kind of go through this and see how things go. If we need a motion, we can do that at the end.
Okay.
I guess is what I would say. Yeah.
Okay.
Alrighty. The next item would be, I want to talk about the requirements for individuals who are overseeing the experience in category C. So that's, these are the people who have to get experience under the direction of an LEP or a licensed psychologist. So there's 2 issues here. One is that the law says under the direction of, and it's kind of an odd phrasing. What does that mean? Is that under supervision? So I actually tried to look back at some history. I didn't find anything as to why that wording was used other than supervision. And then I just thought, I'm going to look at some dictionaries and see, direction versus supervision, just kind of start at the basics. And I'm giving you 2 examples, but there are more. Really, they can mean the same thing. Direction. So like Merriam-Webster, direction is defined as guidance or supervision of action or conduct. And then supervision is defined as a critical watching and directing. So there really are interchangeable terms, but it's a little confusing for us, or how to, what do you call somebody that's under direction? We have the word supervisee, but we don't, directee doesn't really work, or, also, do you call that person a director? That's not really something that's used, that director usually means like the head of a department or an organization. So we are proposing to just change this to say under the supervision of, because it really does seem to mean the same thing. And, for our other professions, there is a definition of what supervision means. And we're open to maybe, we want to talk about this, like, is a definition necessary? Kind of went through that process, and Chris had brought that up as well, Chris Jones, our LEP board member, because I did talk to him about this. And he's actually the one that kind of brought up this question about having a definition. But I do want to, let you know there's not a consumer protection issue that's been identified. These people that are being supervised, they're already in a school setting as part of a team and under the school or district supervision. So there already is a structure in place that takes responsibility for that quality of services. And the LEP or the licensed psychologist that's providing the direction or supervision, whichever way you want to call it, they may be part of the school, or they might be an outside supervisor. So they might be, another layer. The other thing to consider is that LEP applicants they're not required to have experience in this category because it's B or C. So B is the in their supervised experience in their school psychology degree program. And in that school psychology degree program, we don't specify this, the type of supervision. And again, that's also being gained within a structure of that degree program. So there's already, they're working in situations where that structure is already in place. The other thing is that current law doesn't address things like maybe there could be a problematic dual relationship between that supervisor, the LEP or the psychologist, and the supervisee. And it also doesn't address the license status of the person who's directing the experience. So we just want to put some very basic things into place that would have those basic protections in place for the supervisee. So that language, all of that language has been proposed, and again, it's showing in attachment B. So the issues are we good with changing direction of to under the supervision of? Are we okay with not having a definition for supervision? So there are those three pieces here. So love some feedback on that as well. Or if you like what we propose, that's fine too. We don't necessarily, if it's good to go, don't necessarily need to have a long discussion on it. I know I'm putting a lot in front of you here, and
mostly, Christy, I first of all, thank you for sharing that also you worked with our board members in this, because obviously I'm not even a clinician, so I'm trying to navigate through something that I'm familiar with, but not so, I can't speak to it. So as even Wendy was saying before, but in the way you post it is definitely clear. We'll have the opportunity also to bring this to the board, right? Correct. So they
yes, correct.
Was mostly my question around that. Are there any other comments or questions for Christy, or we can move forward?
I just want to say I really like defining supervisor and removing the word directing so that there are no dual relationships. I think clarity is great when it comes to this.
Thank you, Abigail. Should we maybe, Christy, finish anything more and then I can go to the public? How would you like to do that?
Sure. I guess, I want to make sure we discuss a little bit whether there needs to be a definition of supervision, since I did pose that as a question for discussion. So if I personally, in everything that I've learned through this and in talking, a little bit with others about how this system works for these applicants as they're coming through it, it doesn't look to me like we necessarily need a definition. But I would, we probably should have some discussion on that, that in particular. But yes, we can keep moving forward. We don't necessarily, need to stop at every piece here. So.
No, but because this is definitely a big part of the conversation, let me go out if there is any inputs from our associations and the people of the public, and just in case, so that we don't want to undermine this one in particular. And is that okay, Chrissy?
Sure.
Thank you. Moderator, if we can go.
Certainly. And we've opened up the WebEx Q&A feature to facilitate public comment. If anyone would like to make a comment, you can look for the question mark, type the word comment into the text box there and click send, or you may raise your hand by clicking on the hand icon. If you are on a mobile device, you may find the hand icon behind the 3-dot other options. And I do not see any requests for public comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Yeah, Chris, let's move forward with that, and then we'll see if there are any other inputs.
Okay.
I'm sorry, this is Christy Shields from the legal office.
Oh, go ahead.
So, Christy, can you just confirm for me? I don't believe this has been reviewed by our office yet. So, again, I just kind of got assigned to this meeting last minute, so I'm not sure where we are in the process, but typically before it goes to the board, at least, usually before committee as well, but our office kind of reviews it for, the 6 standards that we need to meet in order for a regulation to be adopted by a state agency. So it's up to you whether you want to see it before or after legal review. But if you want to see it after legal review, I wouldn't pass it to the board at this point. If you're just okay with it in concept and you want the board to actually look at the finished text, then you can pass it on, but we're going to probably have changes to this text. So it's up to you, but I just want to let you know that legal hasn't reviewed it yet.
Yes.
And tell me if I'm wrong, Christine, and also Christy, thank you so much. In the past, the board has
Christy number 2. I'm Christy number 2. She's Christy,
Christy
number
number 2.
1.
Sorry, now I see you. So Christy number 1, our presenter. I know that we weren't going to vote on to the specifics of this, and I've had conversation with the board prior a general review because it also allow us to identify, first of all, the issue that we have before we even could get to that. So I don't know how you feel about this, Kristen, if you want to just withdraw that, but in the past we have brought this conversation to the board knowing that still had to be submitted and for legal review and all of that. So
right. Yeah, so it's kind of a new process that we're having legal review prior to committee meetings. So we've been trying to juggle that because they need adequate time to do it, and then us trying to juggle what we're doing as well. So we'll get there, but I honestly wasn't expecting that this would necessarily go to the board in February, and I don't think there definitely won't be enough time for legal to review it prior to that meeting. So I wasn't expecting this to go in February. So, and if it could come back to committee, it probably will need to come back to committee because they're definitely, like Christy said, they will have changes. So the next time it comes to committee, it'll probably be a much more streamlined item, luckily, right. But anyway, so yeah.
I think perhaps so it does help the board to have an idea about what the conversation is and in terms of, right, what first of all, the issue at stake, but also how we're trying to address it. So perhaps, obviously, because in the past in this conversation, there were a lot of inputs in regards about what is that doesn't work right now and how we can actually address it. So it's still very helpful, even though we're not going to make any decision or pin down, the language, because obviously it has to be evaluated still. So,
right.
I can see it is not an easy conversation also because, again, when we go to the board, we have a lot of feedback, in particular by our clinicians in regards to this.
For sure.
That's definitely even the struggle right now in the conversation. But if anything else that you would like to share, and maybe we can just also send this to the next PNA after it's been legally reviewed.
Honestly, I guess there's just really one other piece that I wanted to talk about today, and that was staffing agency placements, because we're increasingly seeing that. And actually, when I did the search for school psychologist jobs and was looking for the private school job descriptions, like I want to say 80% of the listings were for staffing agencies. So, and that's reflective of the shortages out there and the challenges out in the field. So there were, and I again talked to Chris Jones, our LEP member, about this issue as well, and he did have some concerns. So we were also proposing that we have potentially, it may or may not be an issue. So maybe we should bring this back, and I'll I'll reach out. Chris was going to reach out to CASP, the California Association of School Psychologists, about reviewing this, even if they weren't attending the meeting today. So if we bring this whole thing back to the next meeting, I can make sure they've reviewed it by that time, or at least they'll be, see if they can attend the meeting as well. So yeah, let's just go ahead and I think I'm fine. It would be fine to just say we're going to bring this back. But if there is any feedback on this this staffing agency issue, anything that you can tell me today, of course, is something that we can try to work on in the meantime. So if you see anything, let me know that we can work on in the meantime. Let's put it that way.
Okay. That sounds fair. Thank you so much, because I know you've been trying to make a decision as well. Yeah. Any other things to my board folks, if there are any other questions or comments in regards to what Christy has addressed so far? Okay.
What did Chris Jones say was the concern about the staffing agency employers?
Right. So the concern was that, sorry, I didn't go into that, is that for some placements, the depth and breadth of experience that they gain might be limited. So for example, I found some that had their jobs were like a 13-week assignment, or some were completely remote. But then again, some of them are full-time and designed to lead to a permanent placement. So they really vary. So it's just that concern about the depth and breadth of experience that they might gain.
Oh, and they're documenting their hours and...
No, they don't document their hours. For LEP, it's very basic. It's they don't document hours. We don't have a specific hour requirement. So it's the 2 years full-time experience as a credentialed school psychologist in the public schools, plus an additional year, which is either the 1 year in an accredited school psychology program supervised, or an additional year as a credentialed school psychologist supervised.
Oh,
so it's very basic.
So the concern is like that some people are jumping like within a year from like these small assignments, and
they might not get that breadth of experience to become a person who is going to be in practice independently as opposed to within the school system. So is it possible that they might spend their whole time just doing evaluations and not doing therapy type of thing? So is their job more school psychology, which is the psychology end of it, where they're doing assessments and things, versus or maybe they're in a job that's doing more mental health and less of the strict assessments. So there's those kind of ways. But again, it's 3 years full time. So in the grand scheme of things, if there is some temp agency or staffing agency experience, as long as it's maybe, it may not be an issue at all. So we just wanted to, talk about it a little bit.
I guess like how would we measure, excellence? Because we don't know either way. We don't know.
Right. So the thought was we could do something similar to people who, if it even is a concern in the grand scheme of things, we could ask people our applicants to submit we could go through a similar process to what we proposed for the private school placements. Private and parochial schools is having the subject matter expert look at a job description. But then you would also have to, look at it as, did they just have one placement for 6 months and then their other 2.5 years was all at one school, So in that case, they've, it's probably not a concern. But if they've jumped around from one place to the other, that might be more of a concern. But again, it's 3 years. It's probably likely that the vast majority are getting a depth and breadth of experience they would need. So
could we set like a minimum time period where for that experience to count? So if they're there for a couple of days, maybe it doesn't, but if they're there for 14 days or 30 days, then if they're even as a temp agency, if they're there for a little longer, they're probably dealing with a little more diverse set of items.
Right. So maybe I see where you're coming from there. We could think about something in that realm. I'd have to think about it, but I see where you're coming from.
Yeah, and that we can like a check off what the experience was, that we know what was gained during that time. Like there should be some criteria for what's considered experience.
Right. So maybe some sort of limit on this type of work, some sort of, yeah, we can kind of play around with that and see. And again, talk with the California State Association of School Psychologists, because they likely have some insight on this as well, and get their feedback. So.
Great, thank you, Abigail, for that too.
Yes.
I think, is anything else, Christy, you would like to bring to our attention before we move to the next one?
No.
That you could, I know we haven't really fully discussed as maybe you were expecting. So
that's
but
okay.
I really do believe this is going to be a very more rich conversation once we go to the board and with the modification applied and so forth, so we can actually even focus on this too. So if it's okay with you, can we move to the next item in the agenda?
Absolutely.
Thank you. So we're moving to item 8. I know it's also under your jurisdictions, and it's discussion and possible recommendation regarding changes to enforcement regulations, such as unprofessional conduct, amount of fines, uniform standards related to substance abuse, and disciplinary guidelines. And the floor is yours.
Thank you. Thank you. So I think this is the third time this has come to the committee, and we've made changes each time. The most recent changes are still undergoing legal review, but we wanted to bring the latest changes to the committee to see if there are any concerns about anything that we worked on. So I'm going to skip over a lot of this and just kind of focus on the bigger changes and also things that the committee has discussed at the past meeting. So, okay, so where I want to start is that we did move the, in the penalty guidelines, is engaging as, let's see. Oh no, sorry. Yeah, penalty guidelines, engaging in sexual orientation change efforts with a patient under age 18. At the last committee meeting, the committee directed staff to change the minimum and maximum penalties for that violation to instead require outright revocation or denial for these due to the severity of impacts that this violation has on these vulnerable clients. So I just want to make sure that you saw, or that just to confirm to you that we did make that change.
I did see that.
Yeah. At our last committee meeting, we discussed the penalty guidelines for improper supervision. And we had talked about the fact that suspension of a license may not be appropriate or supervised practice, because when somebody is on probation, they already are not allowed to supervise. And just because they might not be a great supervisor, there may be nothing wrong with the clinical services they're providing to clients. So we decided that to go ahead and move the suspension and supervised practice to the maximum penalty side. So
okay,
I just wanted...
makes sense. It makes sense, yes.
Okay.
Yes.
Gotcha. The next thing I wanted to, we're going to skip to the model disciplinary orders section. And we're going to, I want to talk about the clinical diagnostic evaluation. There's just a couple things I want to bring to the attention of the committee and see if there's any feedback. So with a clinical diagnostic evaluation, there is a caveat that if, sorry, I know I'm looking upward. I have a screen above me, so it looks kind of weird on the screen, but I'm looking at the text up there. So if for some reason, so once the evaluator completes their clinical diagnostic report, the board can grant an extension, but we need to define why we might give an extension. So what has been suggested is that we say, including but not limited to, the inability to complete the evaluation in the time allowed due to the evaluators or respondents' personal or family illness or disability, or inability to obtain the necessary patient release authorization if applicable. So I wanted to bring that to all of your attention and see if there were any concerns about that.
How do we reinforce in a way, let's say we did accept, but, and how do we will have to require documentations in order for people to prove, right, that those are the exceptions? How do we go about doing that?
That is a good point.
Because now that too can open a can of worms about, I'm not against the idea, I'm just saying.
No, it's a good question.
A broad thing that could say, okay, anything could be personal illness or family illness, right? As a, people that you're taking care of, that they're directly dependent from you, that you can't obviously be away from, or there are millions of circumstances. So if we go there, then we have to be very specific. Otherwise, it's a big.
Right. I do want to mention that Gina Bieber, who's our probation manager, is here. So if she has any feedback, or she's been involved in these discussions, but also, Gina, if you can answer any questions, please feel free to speak up.
That's great. Thank you for saying that. Yeah.
I'm here and listening. I did have trouble hearing Max. I don't know if maybe he's far away from the mic or not, but.
I'll try again. Usually I have the opposite problem. People tell me that I'm too loud. But I was saying, in those, I was just concerned about, not in disagreement, but it's like, if we are identifying reasons why there might be some exceptions, then we need to be a little bit more specific, because, for instance, a way for personal illness or a family member illness. The other one was, let me scroll up. So maybe we need to be a little bit more specific. Otherwise, that too could be a big gray area too, or maybe we don't need to. So I don't know if you feel like that there is a need to do that, because.
Yeah, this is feedback I think that we got from DCA Legal, right, Christy, that we needed to add this. I can tell you what the delay is, or the excuse that I get for not being able to provide the evaluation within 10 days. And it's simply that their calendar is busy with clients. So they usually take the 30 days, to be honest. And that's always been an exception that we allow, but I think now we're being told that we need to state what the exceptions are. And I don't know if that's more of something legal can help us, get the verbiage right or not.
I mean, it makes sense to me, and that's why your input is really important, because obviously you're at the very end of seeing this. I'm just wondering, and I could be totally off on this. So if you accept the reasons of exceptions because of personal illness, is just based on stating that, or now you're required to collect information, like, I don't know, I've been in a hospital, then show us the hospital, whatever. And I don't know how you go about determining that. I'm just curious.
Right, and it looks like
this is Christy Shelch from the DCA Legal Office, and just following up on that point she made. So the Office of Administrative Law requires us to prove our regulations meet 6 standards. One of them is the clarity standard. So if, as you've correctly pointed out, there's ambiguity as to how that extension would be granted, we have to say exactly under what circumstances that would happen. Excuse me.
Okay.
Sorry, hold on a second.
It's okay. Please take your time. We don't want you to struggle with that.
Sorry, I had to clear my throat. So the problem here is that the way it's currently drafted, there's no explanation, as you indicated, about as to proof, under what circumstances, and how. And I think those things need to be clarified here.
Right.
So we'll need to do some more work on that and bring it back to you, I think, for further review.
Okay. And that was just my thing is like I'm totally in favor of those options. I was just wondering, as you all know better than I do, those gray areas that can allow any kind of justification. So okay, that's not a problem. Thank you so much for chiming in on that. Yeah, that was just the only thing I wanted to bring to.
Yes, that's very helpful. Definitely. We will work on language for that. It's a very good point.
And
okay.
Anything else?
There's no other comments. I'll move on to the next one, which is under the psych evals. So this one, it used under the qualifications for the evaluator. The prior version said possesses knowledge, training, and experience in the area involved in the violation. And we, as we're reviewing this, it kind of wondered, what does that mean in the area involved in the violation? That's kind of an unclear statement. And in talking with Gina, really, and Steve, really what we want is them to have experience performing psych evals. It's not that they need to have experience in the area involved in the violation. So that is a change we're making here, or proposing to make here, and also under psychotherapy, because that one also said that. And but we'll get to the psychotherapy section next. But I just wanted to point out that that was a change that.
Okay. Chrissy, do you think it had to do with a lot of conversation we had in the past, even years ago, about some additional education in terms of expertise around the matter of the dynamics, in this case of substance abuse, how it manifests in certain circumstances? For instance, the drinking level, and how for, regular people, that number is not typical. And for people that usually are accustomed to drink a lot, that value, the levels do signify someone is really used to consume alcohol a lot. And so it might tell us more than just, oh, they weren't drunk at the time, but they have an issue perhaps with alcohol. Do you remember all the conversation around that? I wonder if that statement was referring to that level of education that has to do with identifying really the possible dynamics beyond the numbers, right? Because again, I remember in many cases in our disciplinary actions, it came forward that we had a judgment that didn't take in consideration those elements. So do you think that part is speaking to it? I just don't want to assume it. I don't want to create more.
I wonder, so clinical diagnostic evaluation is more used for substance use. And that one does say they have to have 3 years of experience conducting evaluations of health professionals. And that's part of the uniform standards. When we get to this, I know there can absolutely be substance abuse issues and other issues, but the area involved in the violation, even if we're talking about substance use, be something completely different that's not,
okay. No, I see what,
Yeah. So, but what we could do, so we're saying possesses experience performing psych evals. We could also say something about the mental, if there's any mental health condition, but we're not going to know that until the evaluation's done. So,
exactly. Yeah. No, maybe that's the way it is correct. So
it's a good question, though. Okay.
Yeah. Anyone else? Feel we're good.
Okay.
And maybe we can finish with this, and I can open to the public, Christy, in case.
Sure.
Anything else?
Okay, so the next one is the psychotherapy term. And the latest amendments would allow a registrant to be someone who can provide psychotherapy in addition to a licensee. So we've made that change as the committee directed. Again, we've stricken the requirement that the therapist have knowledge, training, and experience in the area involved in the violation. We've also stricken the wording that says they can't be the respondent's supervisor, because that really duplicates what's in the prior statement, saying prohibiting them from having a professional relationship with the respondent. So we really don't need that one. It's not that we're saying they can be the supervisor. It's just it's duplicating.
It's redundant. Yeah. Can
Right.
I ask you what page are you in? Because I lost you on the document.
In the uniform standards, I'm on page 38. I'm in the document itself. I'm not sure because I'm working from two different.
Yeah. Don't worry. Don't worry.
Okay. So back to psychotherapy. Oh, the other big change is that we're specifying that the psychotherapy would need to be provided on an individual basis. And because it was pretty generic before, it just talked about psychotherapy. It didn't say if it had to be individual, group. So we're specifying that it must be individual.
Max, she's on page 4, by the way.
Yeah, no, thank you, Abigail. I found it though. Thank you so much.
Okay.
And then
the next.
Yeah.
Oh, of the memo. Yes, I'm on page 4 of the memo, but of the actual document, the disciplinary guidelines document. Well, now I'm moving on to page 40 for the next one.
Right. I saw that actually the memo is very clear about.
Oh, that's right. It's right in front of my face. Yeah. I forgot I even did that.
After I asked you, I realized it's going to send us exactly to the page. So it's perfect. Don't worry. Don't mind.
Okay. Good. Okay. So, oh, go ahead.
Go ahead.
Supervised practice is the next one. If you want to, this one's kind of related to the last one too. It has some similar provisions. Again, it's striking the requirement that they have the knowledge, training, and experience in the area involved in the violation. And the other thing that's, I would say, significant here is that we are specifying how the respondent must proceed if their supervisor is suddenly no longer available. So what we would like to say is that they have to submit for approval the name and qualifications of a new supervisor within 15 working days, and then clarify that if the respondent doesn't secure a new board-approved supervisor within 30 days, that they shall not practice until a new supervisor is approved. And we feel that this allows an abundant amount of time for the board to vet and approve a new supervisor. So even if it comes right at the end of that 15 days, that gives us, plenty of time, because usually this is being done through email. And, it's in talking with Gina, it's a pretty quick process to review and approve.
Okay. The fact that it's not a quick process of finding another supervisor. Sometimes we heard the challenges that people endure to do so.
Right.
Especially when they're under, review and so forth. It's not an easy task, but yeah, I think it's definitely more than what we used to have. So.
Right.
See it here. That's clear.
Yeah.
You want me to go with this to the public, or you want to continue to finish and then I can go out?
We could stop here because this is kind of a good stopping point if you want to kind of break it up.
Okay, let's do that. Unless there are any questions from the board, and then I can go out to see if there are any comments or inputs. And moderator, if you don't mind to open, thank you so much.
You're welcome. And we are opening up the WebEx Q&A feature to facilitate public comment. If you've got any comment on this discussion, you can look for the question mark icon in the lower right corner of your WebEx screen. Type the word comment into that text box and click send, or you may raise your hand by clicking on the hand icon. And if you are on a mobile device, the hand icon might be behind the 3-dot other options. Each person will have 2 minutes to speak with a 15-second warning. And I do not see any requests for comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Okay. So I guess we'll move on then to the next thing that I wanted to bring your attention to. Taking and passing the licensure examination. So in past iterations of this, we had proposed to strike this penalty. However, DCA Legal, for a couple of reasons, but DCA Legal has strongly recommended that it remain. So we're going to go ahead and keep it. And I don't want to get into that too deeply, but it's, it's there. If somebody wants to use it, it doesn't have to be, because these are guidelines. But we did make some minor changes to the text that describes that item, just for clarity. So, okay, recovery support program. So this is something that the committee has discussed. And what the latest amendments would do, and this is for them going to AA meetings, recovery support programs, basically. So we worked on this a little bit, and so what we needed to specify when they had to begin attending meetings. So we're saying within 30 days of the effective date of the decision is what we're suggesting. We're put in language that clarifies that it may be a recovery support program or a facilitated group led by a mental health professional trained in alcohol and drug use treatment. We're specifying the acceptable proof of attendance, and then just clarifying they must continue the group for the duration of probation unless notified by the board otherwise. Oh, and also, I'm sorry, what the board must consider when determining the type and frequency of recovery support program meeting attendance. So things like the documented length and sobriety time that has elapsed since substance use, their treatment history, their nature, duration, and severity of substance use. So just that, specifying that criteria.
Okay.
All right. I'm sorry.
No, go ahead. Go ahead. We're good.
Should I go ahead? Okay.
Yes.
Thank you. The next term is the relapse prevention plan. So this is not in the current disciplinary guidelines, but we had previously proposed to add it. And the reason we thought about adding it, well, there are more than one reason, but originally it was because we sometimes have respondents who don't meet the criteria to enter a substance abuse rehabilitation program, and felt this would be a potential alternative. But after consulting with DCA Legal, it was clarified to us that if a rehab program is included as a penalty and the respondent doesn't meet the criteria, the board could reduce the penalty. So that is something that can be dealt with in a different way. And then at our October meeting, the committee had discussed whether this term was necessary, because there's already the option of requiring the respondent to attend a recovery support program. There were also some questions as to the efficacy of this term in the context of probation. And so the committee had directed staff to gather information from another board that has this term in their disciplinary guidelines. So I contacted the Board of Registered Nursing and spoke to their probation manager. They actually BRN actually has their own relapse prevention plan form even. So that's why I picked them, because that had been provided to me previously as an example. So they were really helpful, gave us some really helpful feedback. They actually have a diversion program, but they also have, people who are in probation. So two separate sort of pathways. He said it is helpful in a diversion style program, which our board does not have, but has not been particularly helpful in their probation program. So we were talking about how, it's common for individuals in recovery to relapse, even with a plan in place. It's just part of the process of recovery. But the bigger issue for him is that his feeling is that, you know, when, and what he's seen is when it might be a little misleading to the respondents because, you know, we have to automatically suspend their license when they do have a relapse. So uniform standards require that. And it doesn't matter if they have a relapse prevention plan in place or not, they'll be treated no differently. So he felt that it's misleading in a way to them because they might assume if they have a plan, the board might allow for something other than a license suspension when a relapse occurs. So that was our conversation there. And then the other thing to consider here is that when a respondent petitions for reinstatement to a full and unrestricted license, per the uniform standards, a licensee must demonstrate that they have a relapse prevention plan. So it does come into, you know, it does come into play at that point. So the question here is, you know, after gathering this information, we decided to propose striking this this addition that was previously proposed.
Sense. Still makes sense. Okay.
And not to say a relapse prevention plan can't be helpful to an individual, you know, it's just, it's
right.
In this context.
It doesn't, yes.
Yeah.
Shouldn't be there. Okay. Anything else?
Yeah, I also think that it puts us in a position of like, kind of create like almost forcing people into recovery. And here we're just focusing mostly on like people not being a threat, I would say, to the consumers. So like I know there's like a fine line between the two, but I feel it's more like forcing sobriety or things like that onto people that have DUIs or, you know, that are on probation. So I don't know. I think there should be choice, right? That they choose that path. And that if they do violate, you know, or get another DUI or things like that, then, you know, we're in the jurisdiction around their licensure, but not like if they want to change their whole lives. That's what I've kind of been, you know, as I've been on the board this past year, like, you know, are we here to like enforce treatment, you know, or just that people not break the law.
Right, it makes sense.
Yeah.
That's good. Anything else? That was clear. And I see all these these are not substantial changes that actually have been reflecting the conversation we had, Christy, as you know. So it's been really definitely a conversation we have had for quite some time. And I really appreciate all of this editing because while, you know, require more discussion, but at the same time, they're really reflecting everything we have been addressing so far. So thank you.
Thank you.
Anything else? Christy?
Yeah, okay, so I'll continue on then.
Yeah.
Okay. The next thing,
just trying to regulate. I think we do need like a 10 minutes break just for, just to interrupt for a second, but I was trying to find the right time. I think maybe we should finish this and then we have 10 minutes.
Yeah, there's not much more.
Right.
Not too much more.
Okay.
Okay, so we have an updated quarterly report form that's, this is the first time it's coming to committee. But it's, again, nothing really earth shattering there. It's really minor changes. The next thing I want to call your attention to is under the failure to practice and tolling section. We have another definition of good cause for failure to practice for 2 years, which is normally considered a violation of probation. But we're going to define good cause as, we're proposing to define good cause as including but not limited to a personal or family illness or disability. So I wanted to get feedback on that. And the same thing, Max, that you said about the other term under the clinical diagnostic evaluation. I think this is one that we'll need to figure out the documentation of that.
Right.
But if there's something else that we should maybe add here, or that would be some feedback. I don't know that we really want to, give ideas here, expand it, but again, if there's, because tolling, this is, we want the people, people who are on probation, we would like them to finish their probation and not have it paused, basically, so.
Even though there are circumstances, as we know, we experience it, they are, just occur, right?
Right, exactly. So we, want it to be a good cause, but these were the two areas that were suggested.
Yeah, I don't have any additional comments. I think it's always very complex to add more. I mean, there is always the reinforcement aspect of, how far are we going to require people to comply in terms of documentations?
Right.
At the same time, even when it comes to tolling, again, from the consumer protection standpoint of view, if someone is not in the right state of mind to practice because of what happened to them, they're still not recovering from it, right? Or whatever the conditions is, we want to make sure that they do take advantage of that, because we don't want them have to finish forcibly have to finish their time by practicing when they don't have excuses that could be justifiable, from the standpoint of view of whatever paperwork we're going to require. So I just want to be careful with that too, right?
Right.
If someone is not in the right state of mind to proceed, and maybe they are not in a hospital, they are not in a circumstance. We just want to make sure for consumer protection that also we do acknowledge that. That's the only concern I may have.
For sure.
Too strict.
Can I interrupt this conversation?
Okay.
Yes, of course.
We need to take a short break right now to reestablish a quorum before any further discussion goes on.
What's going on? Who left?
Someone just stepped away momentarily, so until we can get her back, we do not have a quorum.
I didn't notice that. I would say perhaps, Christy, if we can do that, because we have been really going from 3 hours.
Yes.
Perhaps let's take a 10 minutes break, and it will reconvene it's 3:55 right now, 4:05 just for, and also making sure that that we have a quorum too. So can we do that? We reconvene at 4:05. We're good. We're resuming, and we were just having Christy finalizing that item. Am I correct?
Excuse me. Hi, this is Christy Shields again. I just have one question regarding the last item that Christy covered.
Sure.
So the last item that she covered in her summary had to do with the tolling provision.
Right.
Absent good cause is approved by the board, the failure to practice for a total of 2 years should be a violation of probation. Respondent may not request. Okay, so our office's recommendation was to delete that actual proposal, because with tolling, we don't want to allow people to continue to retain the license if they're not fit or competent to practice. And so We give people 2 years to remain in non-practice because the idea of probation is to allow people to show us that they can still meet minimum standards for competency. So if there's a problem with illness or other issues affecting their ability to practice, then the question is, should they still be in practice? And that's something that's properly before the board. It shouldn't be delegated to anyone else to decide, and they would need to come and explain to the board why they should still keep their license in a petition to revoke probation proceeding, or if they want to modify their probation. So typically, and I've never seen this before, tolling does not have any kind of good cause exception. So I think our office is recommending not to include that in there, because otherwise you have a situation where people could be on probation for a long time because maybe they're ill for more than 2 years. So then they're just going to be on probation, or they'll run their probation out. And so either one of those options are not good options from a public protection perspective. So that's why those issues, Max, that you raised previously about public protection are right on point. And it's why our office recommended not to include that in this section. And I thought we kind of had come to a conclusion with staff that that wouldn't be included, but I see it's still here. So I think that my advice to you would be to not include that provision for tolling for the reasons that I've stated.
Thank you, Christy. I know Christy Berger, I'm sure you were replying to that.
Yeah, I just was wondering if Gina recalls what the discussion was, because I thought Christy had given us the good cause language, but maybe it was because we had discussed, you may have said recommended against it, but we may have said, no, we want to keep it. But I thought the good cause language, Christy, had come from you. So I was just wondering no, okay.
Yeah, no, if you look at my October revisions to you, the revisions explained that we didn't recommend giving people an out when it came to tolling. Either they're going to practice or they're not going to practice in California. And that's what tolling is about. And that's the way it works for all the other boards I've worked with. They get 2 years to toll, and then they have to show that they can still practice. If they can't, then they're subject to a petition to revoke their probation. And then they can prove at that hearing, oh no, I'm fit to practice. And if they can't, then they maybe have their licenses revoked or surrender their licenses at that point. We want to make sure that people are fit to practice and that they're monitored continuously for probation. That's why the tolling provision exists. It doesn't let people sign up for probation and then simply not practice and let it run out, and then they come back into practice without having to comply with probation. So that's the idea behind tolling. It's like, okay, if you're not going to practice, then we're going to freeze your probation at that point in time, and the clock will not continue to run in your probation until you come back into practice, so that we can monitor you based upon either the stuff that you agreed to in settlement or that was applied as a result of a hearing. So that's why it's really important this tolling provision be very clear about how you're going to operate, and that the reason this tolling provision exists is to not allow people to escape probation by simply sitting out of practice until their probation runs out. So that's the whole point of tolling, is to say toll means you freeze for that period of time. And then when they come back in, then the probation clock on their 5-year probation starts ticking again. We don't want to let people say, oh, I'm sick, I can't practice. And we're like, okay, you can continue to run your clock down. No. You come back when you're well, and then we'll see if you can actually practice with terms and conditions. Because whatever happened that caused you to be placed on probation is something we need to watch to make sure you don't do that again to another consumer. So that's where I was surprised to see that in there again. And so I think that my recommendation on this item is that I meet again with staff when we go over these areas again to make sure we come to some agreement, and where we don't agree, then you can make the tie-breaking vote, because that's your job to decide what you want to do. But that way we don't waste your time where you feel like you're getting different guidance from legal and maybe different guidance from staff. And so I'd like to recommend that this item be tabled for a future committee meeting, and we bring back to you what we end up doing to resolve this issue and any others that might be there. That's my suggestion, but you can of course proceed as you wish on this item.
This is Gina. I just wanted to kind of give some history to this term. So how it's written, which is stricken out in this document, is how it's in the disciplinary guidelines now, at which we have found that that is not legal. We have to have due process. We can't just cancel somebody's license automatically. So that's why it's stricken out. Once we found out that it was illegal language in there, we have started to write in our stipulations just simply the failure to practice for a total of 2 years shall be a violation of probation and subject to, I don't know exactly how we say that, but subject to discipline or whatnot. That's how we're writing it in there. We're changing it and taking out the stricken sentence and rewriting failure to practice could be a violation of probation, basically for a total of 2 years. The good cause, I think that we had a conversation about that, Christy, and we thought, well, COVID hit and then people were sick and not able to get a job and things were happening, and we talked about that. And then we talked to Christy, the other Christy, and I think we decided, yes, that needs to come out, the absent good cause part. Maybe it just got overlooked when, but I think we did agree to take that out. The problem with this, without having this, I should say, is for people that had got stipulations or proposed decisions that were adopted that said that their license shall automatically be canceled, those people we still have told. They've been told for 10 years, some of them. So that's where this came into play, where we had to do something to give a deadline to them to get back to practice, to finish out their probation. So that was the problem with not having a deadline. So I agree with you, Christy. We need to get rid of that and just move forward and get these people to finish their probation and practice or don't.
I think that maybe the wires got crossed in the interpretation of what I meant about bringing this back to the board. So people who are unreasonably told, they can always bring their case back to the board and ask for a modification of their probation. Okay. And so that's the mechanism for correcting errors that we find down the road. The reason I brought this issue to your attention was because there was a case where the medical board had litigated the question of whether they could flip someone's license during a tolling period, and the court said they could not without notice in a hearing. So I recommended that language be struck. If people, like for instance, COVID happens and people have extraneous circumstances, again, the mechanism is for them to bring back their case to the board and ask for modification of their probation. But as a standard term, meaning going forward in every case, we want to start from the proposition that you only can be on probation if you're actually monitored by the board. Because what's the value of probation if you're just allowed to sit out for whatever reason for years and we can't evaluate whether you're rehabilitated or not for the protection of the public? So we start from the proposition that we assume people will be able to get back into compliance within 2 years, which I think is a reasonable amount of time. And that's common amongst the boards in this department, 2 years to get into compliance and come back to practice. If they can't come back to practice in 2 years, you have two pathways. One is to revoke the probation, and another, and they can prove that they're still fit, or another is maybe to revoke based on a fitness for competency, mental or physical evaluation to see if they're fit to practice. So there's a lot of ways to go through it, but I think my advice to you generally is we don't want to allow people to escape evaluation and monitoring by the board. So what we're saying is let's just stop at it's a violation if they don't practice for 2 years. And then if there's extenuating circumstances, they can petition. If there aren't, then it's a grounds for revoking the probation because they may not be fit to practice or they may not want to practice. So in either case, we need people that are engaged and want to work under their license and want to comply. Those are the people that are rehabilitatable. So that's kind of my general advice and why I had recommended striking in October. I had recommended striking that last sentence that I thought we had agreed we don't need, because there's other ways for people to deal with these other issues that doesn't affect our ability to protect the public.
Wow.
Good conversation, definitely. So yeah, that may just be something that got somehow. So apologies there. So yeah, we're going to need to schedule a meeting anyway, so we can. That seems very clear. So
right. And I might have to say that also in the 6+ years I've been on the board, in at least on the cases that made it to the board to discussion, and we have seen tolling, they were usually quite because people want to move forward, right, and not having the to deal with supervision or other probation terms for too long. Usually we've seen people, in the worst scenario, I've seen people tolling maybe 2-3 times or 2 times, but always for a short time, maybe because they moved or whatever were the circumstances, or they lost their job. And but I always seen an average of 4 or 5 months the most, right? So we never seen situations where people really needed to toll for a whole year, a year and a half, and so forth. So at least for the cases I can speak to, they came to the board. So it's definitely to be noted. Okay. Christy, would you like to? So are we done with this? I mean, in terms of like, so maybe I can open to the public in case there are any other inputs. And
I have one more section to go over.
Why am I?
One more. We're almost there.
Am I missing that? Which one?
The last one is the reinstatement and reduction of penalty hearings. So the language for that.
Okay. Mm-hmm. I see it.
And so we added language from statute, just so that, because it really should be there. If it's in the statute, we don't want that to be missed just because it's not in this document. So we did add that. But we are proposing striking language that talks about the petitioner's attitude toward their commission of the violations and their attitude in regard to compliance with legal sanctions and rehabilitative efforts. And because what do you mean by attitude? You know, and that's, to us, that felt like a strange, word. It's understandable, but the word, we kind of maybe can think in our heads what it means, but to lay it out and have it in text here, we'd rather kind of describe what that means as opposed to just using the word attitude. So what we want to say is more like the petitioner has cooperated with the board's investigation, other law enforcement or regulatory agencies, and or the injured parties, because that's really, that cooperation is easier to define and show as opposed to an attitude. So that's really it. It was the last thing that I wanted to bring to your attention.
Okay. And perhaps unless there are any comments around this from my fellow board members, that we can move forward. I don't see anyone. So just for clarification, we can see now some of these things were from the whole document were pulled. I know the original recommendation is to obviously adopt the technical changes, right? For a motion that would do that, or what would you suggest? Yeah.
We don't need a motion because this is going to come back to the committee with additional changes. So, but again, it'll be more streamlined at this point. I'll just show you the changes since this meeting.
Wonderful. Thank you so much. And let me just open to the public so we can conclude this agenda item and making sure that we don't miss anyone out. Moderator, if you can please open out to our public members. Thank you.
Certainly. And we are opening up the Q&A through WebEx to facilitate public comment. If you would like to make a comment on the issue, you can look for the question mark icon in the lower right corner of your WebEx screen. And in the comment box, in the text box, type the word comment and click send. The other option is anyone can raise their hand to ask to be recognized, and that would be done by clicking on the hand icon, which if you're on a mobile device might be behind the 3-dot other options. And each person will have 2 minutes to speak.
Thank you, Mother.
And we do have a request for comment from Ben Caldwell. And Ben, I will send you a request to unmute your microphone and you will have 2 minutes. You're unmuted.
Thank you, Ben Caldwell, MFT, and thank you, Christy. I know there is a lot here, and so I really appreciate the depth of work that goes into this. As far as my read here goes, this is all fine. I mean, there's a couple of pieces that just strike me as weird. One of them being the language around a recovery support program, attending a recovery support program, because from a perspective of evidence-based treatment, attending a recovery support program does not seem to be as effective as certain other forms of substance abuse treatment. And so this particular mandate has always struck me as odd, but that may be beyond the bounds of the current conversation. And I hope that at some point the board will take a holistic and data-driven look at the disciplinary process. Just because and Steve nodding, he's heard me say this before. It seems like the majority of people who are put on probation don't complete it. And that's pretty troubling data. And I think it would be really helpful for the board to understand why that happens, why this process that is meant to be rehabilitative more often winds up actually pushing people out of the licensed professions. So I really just want to say thanks. Like I said, there's a lot here, a lot of detail, and the language changes that are here are fine. Thank you.
And I do not see any other requests for comment at this time. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Okay, wonderful. Christy, thank you so much. I believe also the next agenda item is an update on board-sponsored legislations. And that is it still you, Christy, or back to Roseanne?
Roseanne.
That's going to be back to me. Yeah.
Back to Roseanne. Christy, thank you so much for all this hard work. We really, really appreciate you. I know it was a quite tense and
thank you.
A lot of things, but we really appreciate you. So thank you so much. And Roseanne.
Okay, so as I alluded to earlier, our temporary practice bill proposal has been introduced as of last night. It is AB 232 by Assemblymember Aguiar Curry. So we'll look forward to, based on the information today, we'll take those proposed amendments from Ledge Council to the board and then amend them into the bill if the board approves them and then move it along. So there's that. And then also we are working on a couple of items that the board approved in November to include in the Senate Business and Professions Committee's bills omnibus bill proposal that they do every year. So we've turned that approved language into the committee, and at some point when they introduce the omnibus bill, hopefully they will include those items. So that's the information we have for you about legislation. The legislative session is just getting underway, so we're monitoring here at the board staff. We're monitoring the bills that are getting introduced, and we'll have some bills in the upcoming months for the board to examine and discuss and take positions on.
Wonderful. Thank you, Roseanne. I know we are not moving forward to any, this is just informative, but just if there are any questions from the board. Nope. Moderator, can you please open to the public to see if there are any questions?
Certainly, and we're opening the WebEx Q&A feature to facilitate public comment. If anyone has anything that they'd like to comment on with the update on board-sponsored legislation, you may look for the question mark icon, type the word comment in the text box and click send, or click on the hand icon to raise your hand. If you're on a mobile device, you may need to click on the 3-dot other options in order to get to the hand raise feature. Each speaker will have 2 minutes to speak. And I do not see any requests for public comment. Shall I close that feature?
Yes, thank you.
You're welcome.
Okay. And thank you again, Roseanne. So I think we can proceed now with item 10, which is update. Am I correct? Yes, on board rulemaking proposals.
Yes, that's back to me, Christy. Our continuing
Back to you.
education and
Yes.
okay. Continuing education and additional training requirements regulation was approved by the Office of Administrative Law and takes effect July 1 of 2023. I'm also happy to report that our next regulation process, the status here shows it's awaiting final approval. We did get that approval. So that our examination waiting periods, professional corporations and accrediting agencies, regulation package, it's really minor changes that it made, but that will take effect April 1st of this year. And then the other regulation package we have here is our enforcement process. And that's normally we wouldn't have it in the memo yet, but because this is something that had been started back in 2015 or 2017, we've kept it on here just to give updates. So, and that's all I have.
Wonderful, thank you.
Christy, quick question. The exam waiting periods, AOL approved, and it'll take effect when?
April 1st of 2023.
Thank you.
Sure.
That's great. Thank you. I don't believe we need to open, that we need to, unless there are any questions for Christy, but I think that was really straightforward. So, okay. At this point, we're moving to item 11, which is suggestion for future agenda items. I will ask first to our fellow board members if there are any suggestions for future agenda items. Okay. If you can please open to the public, and so we can see if there are any suggestion for future agenda items, which not to be confused with public comments for items not in the agenda. So we will go back to that in the next item. So suggestion for future agenda items, if our moderator can open. Thank you.
Certainly, and we've opened up the WebEx Q&A for requests to suggest future agenda items. If you'd like to suggest something, you can look for the question mark icon, type the word comment and click send, or you can raise your hand by clicking on the hand icon. And I see no raised hands and no suggestions. So shall I close the Q&A for now?
Yes. Thank you so much. Thanks a lot. And now we're moving to the next agenda items, which is agenda item 12, public comments for items not in the agenda. If there are any reports or anything that any of my colleagues would like to share, this is the time to do so. Anything that's also unrelated to the items agenda today. Okay, doesn't look like. And again, moderator, if we can open to the public and see if there are any comments for items not in the agenda. As a reminder on this, public comments, the board, in this case, the P&A committee is not allowed to address those items or concerns or intervention, but just to take notes of it. So if you, moderator, would like to open to the public to see if there are any comments for items that are not in the agenda.
Certainly, and we've opened up the WebEx Q&A as a way to facilitate public comment. If you have anything about agenda items that were not on the agenda, you may type comment in the text box and click send, or raise your hand by clicking on the hand icon. And I do not see any requests for comment. Shall I close that feature?
Yes, thank you, moderator.
You're welcome.
Well, at this point, we are moving to item 13, which is our adjournment to our next P&A. Thank you so much for being present and our public as well. We will resume with the Board of Behavioral Science meeting on February 1st and 2nd coming up in the next 3 weeks. So thank you all for participating and have a great weekend.
Thanks, everyone.